And I understand that Commissioner Holton will join us after this. Excellent. All right. On our list is public comment. Just a brief announcements prior to that. As most of you know, from the agenda, the wildgrass matters will be heard tomorrow. So if you're here today to comment on those matters, we would encourage you to defer those comments until tomorrow, and they'll be heard just prior to the matters being heard from the commission. However, if you want to comment today, that's fine as well. I think we have enough time to accommodate that. Some other items. You all know we have a bill in front of the legislature to change how we approach oil and gas regulation here in the state. We are not the legislature.
Yeah. Which one are we on?
No comments made with respect to that bill today will be passed on to the legislature. And I want to let you know that the commission has no position on that bill. With that, Councilor.
Thank you, Mr. Chair. I believe, as is our practice, we have some elected officials in the audience, and so if they would like to speak, any elected officials, please come up and make your public comment. Otherwise, we will go to the online sign up. And in the interest of time, I think I would just sticking 2 minutes for everybody.
2 minutes for everybody.
Okay, thank you.
Any particular place?
Any jerks?
Good morning, my name is Elise Jones. I am a Boulder County Commissioner. Thank you so much for listening to us today. I believe this might be the 7th time in the last 18 months that I have come before you for public comment. And admittedly, I'm usually pretty grumpy, sometimes even angry when you see me, because I have a strong belief that the system is broken for oil and gas in Colorado. But today, I am feeling optimistic and hopeful. So I hope you appreciate the change in emotion there. And that's because last November elections brought a change in leadership on oil and gas. There's a new sheriff in town, if you will. We have a new governor, a new COGCC director, new leadership in the legislature, and all of this gives an opportunity for reform and to change how this agency acts and allows it to be a true regulatory agency where you undertake meaningful analyses of impacts, including cumulative effects, where you ensure that those impacts are mitigated, where you look at alternative sites for wells and facilities that might not be properly located, when you ensure a meaningful opportunity for the public voice to be heard, including small things like holding hearings in a room large enough to accommodate the public, where you put health and safety first and exercise your ability to say no when it needs to be said because the protections aren't adequate. This change also allows us to redefine the relationship between the state and local governments. And as a local elected official, having more local control is something very near and dear to my heart and that of other local electeds, so that we can do what we do best, which is to use our land use powers so that we can look at oil and gas just as we look at and oversee every other land use in our jurisdictions. So we look forward to this new opportunity, this new relationship with you, and I hope that you will seriously embrace this opportunity for a better future for Colorado. So thank you.
Thank you. Thank you.
Good morning. My name is Matt Jones. I'm a Boulder County Commissioner, used to be a state senator. Good to be here again, I guess. I appreciate you taking the time to listen to us. And I'm going to advocate that you take a more careful look and the time to look at the processing of Form 2s and 2As. I'm told that there are about 5,000 of them now. Plus you have all the spacing applications, of course, for schooling. All of that has to be looked at in a way that is protective of people. And there are a lot of those permits because of the 112 oil rush, I think of it as. And it's not just the horrific story of Erin Martinez, what happened to her family and her Irwin family in Firestone, about 20 miles from our house. But it's also the parents that live in places like Erie. My wife's a good friend with Beth Iskowitz, who came in and testified to you. She is the PhD toxicologist and neurobiologist whose son's benzene and ethylbenzene levels are in 85 percentile. It's cancer-causing stuff. I can't imagine being a parent and wondering if your kid's going to get cancer. I've survived 2 of them. It's horrific, and it just points out that we need to prioritize protection. And when you look at bills and when you look at a lot of the work you do, you always see the public safety, health, and welfare of Coloradans. And that should be our priority, especially with all these permits coming in, and being very deliberate about how those permits are reviewed and prioritizing people who live near these that might hurt their children. And so I ask you to do that and take the time to protect people. Thank you.
Thank you, sir.
We're on the online, sign up now, public comment. I'll call names 3 at a time. If you could come up and be ready to speak, that would be appreciated. The first 3 names I have are Patrice Dulani, Barbara Kahn, and Betty Ann Colmer.
Hi, my name is Barbara Kahn. I'm a Windsor resident and a Colorado native. I decided to come here today to talk about climate change, and then I realized that in this context, it's completely irrelevant. Right now, I think we need to prioritize health and safety, and to me, that has to do with improving our air quality. If oil and gas is who we are as Coloradans, then it's time to break away from this part of our identity and enact a change to become who we want to be. And who we want to be is a state with fresh mountain air, and that is not who we are at this point in time. Right now, Denver's air is the 14th most polluted in the US, and that pollution travels across the Front Range to my home. Dirty air kills people, period. It leads to higher risk of asthma, stroke, heart attacks, premature birth, and cognitive dysfunction. It kills 7 million people a year globally. And we happen to know that ozone, methane, benzene, alkanes in the air across the Front Range are directly traced back to unconventional oil and gas production and installation. By limiting or getting rid of fracking, we could address our air quality problem better than we could with just electric vehicles alone, and that's why we must. I want my daughter to play outside with me without me having to race to check the air quality first. I want her to live and thrive, and that's what all the Coloradans want for their children. That is why I kindly request that the COGCC not grant any more permits for new wells until SB 19181 either passes or fails. Communities deserve to dictate what happens near their schools, playgrounds, underneath their homes, and on their own properties. I ask you to take this moment to listen to Colorado. Thank you.
Thank you. Heidi Leafwood, Jim Bensman, and Larry Roberts.
I'm Heidi Leafwood. Thank you for the opportunity to speak today. Will I be able to sign up if I'm here tomorrow, to speak tomorrow as well in public comment?
Certainly.
Okay. So today I would just like to speak about the docket that I'm personally involved in. It's docket 190300199. We received a letter from SRC Energy stating that our docket was scheduled for this hearing today. I'll just quote the letter. The commission will hold a hearing on this matter at the following date, time, and location, and it gives today's and tomorrow's dates, and it gives the other location before you rescheduled it. And then it gives a deadline for protests or interventions. So I submitted a protest by the deadline, and I received a receipt of submission from the COGCC, and I'd like to read that. Hello, thank you for your submission. It has been received. If we have any questions, we will reach out directly on a case-by-case basis. Please keep this email as receipt of your submission. Have a great day. And I received nothing else subsequent to that. So I assumed that this would be on the agenda for either today or tomorrow. And when I arrived, I see that it's not on the agenda. We have spoken with Mimi and clarified that it's not a mistake, that it is indeed not on the agenda. So I just wanted that to go in the record. I do believe that it's not a malicious, intentional, misleading thing, but it's hard to maintain a feeling of goodwill when these kinds of things happen. And I wanted you to know the frustration that I reorganized my life for this week and expected, although part of my protest was that I was given insufficient time to protest, but I did my best to prepare and be here. I want to know, although Mimi has already talked with us, but I'd like to know again publicly, how will I be notified of the new date of hearing? And I would like to know if I should expect to receive the items that I've asked for in my protest letter, including the list of interested parties in this docket number.
Thank you, Trevette. So yes, just a few things to note about this. We, as the hearings unit, are working to try to streamline things and better about getting information out to the public so they understand our processes and understand when their matters are ready. So I do apologize for this. I was going to address this also to the secretary, but just to let the commissioners know and the public know that we are working internally to, on our website, have better processes in place that are in plain language so people understand what they need to do and how they'll be contacted. With respect to the specific matter, the pre-hearing conference process is not yet begun. So when an applicant files an application, that application is then protested. A hearing officer will contact all the parties, including the protesters, to advise them of pre-hearing processes and to get them involved. So that is not yet occurred. Looking at our internal spreadsheet, it appears that no one has yet been contacted, either the applicant or the protesters, to schedule this pre-hearing conference. I don't know when that will occur. I can certainly check with the hearing officer to see when that will happen. But we'll certainly do our best to improve this process and make sure that you're better aware when that's different.
I finally realized I can lift this up instead of crouching over. Thank you. And I do want to also say that the letter that I received from SRC Energy stated that I needed to be available for the pre-trial hearings on February 25th, which was actually the same day as the deadline to submit the protest letter. Some of our concerns are health and safety, and so that's why I would like to sign up again to speak tomorrow, because I know that's relevant to what you're thinking about today and tomorrow with the wildgrass. Thank you.
So, absolutely. Welcome your comments again tomorrow. And as I presume that we'll get notified to your.
Yes, no, sir.
Thank you very much.
Thank you.
Jim Bensman or Larry Roberts. Ronald Booth, Deborah McNamara, and Bill Purcell.
Morning once again. Holidays are over. New legislation.
I hope we all bear that in mind.
Then we have your name, please.
My name is Ronald Brewer. I'm a resident of Westminster, Colorado. And I may go a little bit long, but I promise you this will be the last time that I do. This may be one of the last few months in which this body, as it sits today, will have the opportunity to correct some major oversights, shortcomings that have occurred throughout its history. Your mission statement, in brief, not only states that you will foster responsible, and I want to emphasize responsible development of our oil and gas resources, but it also says it will do so consistent with the protection of health, safety, and welfare, including the environment and wildlife resources. And this has been a great point of contention because the history of this body has shown that it has taken fostering development in Colorado's oil and gas industries, natural resources to heart, but pretty much ignored the rest of its mission statement, as near as I can tell. Evidence of this is that first you created 350-foot setbacks. Those setbacks were not based on any unbiased, peer-reviewed science. It was basically a number pulled out of thin air. Later, that was changed to 500 feet. Again, not based on any science, but information spoon-fed this commission by the oil and gas industry rather than by independently verifiable sources. Then in a ham-handed attempt to appease the justifiable outrage of the citizens around the Del Romero Middle School, he colluded with the oil and gas industry to go with what he called new rulemaking to make a 1,000-foot setback finally for the school children, as opposed to the previous ruling from the building. And it's pretty clear to anyone with a half an ounce of common sense that the intention of the 1,000-foot setback is to protect people, not brick and mortar buildings. So I have 3 requests in the remaining days for those of you who might be leaving this commission and for those who will be staying with this commission. Gather the latest relevant peer-reviewed scientific information that is untainted by the influence of the petroleum industry and create a minimum statewide setback standard based on all the peer-reviewed facts, not the cherry-picked information that is spoon-fed you by the industry. Number 2, that you immediately admit your mistake in issuing extraction oil and gas, the permit that allowed them to place children at risk at the Del Romero School in Greeley, and withdraw that permit and require extraction oil and gas to shut down their operations there. And finally, I request that you cease issuance of additional permits until that science-based, fact-based setback has been established. Thank you very much.
Thank you.
I go ahead.
Yes, please.
So I'm Deborah McNamara, and I'm speaking on 350 Colorado, but first I'm actually just speaking personally as a Boulder.
Ms. McNamara, I apologize. See that little red shiny light? You have to
Yeah.
hit the button on the front of it so it turns green. There you go. There we go.
Thank you. So I was saying I'm Deb McNamara. I'm speaking personally first as a Boulder resident, and then I also have some comments on behalf of 350 Colorado. So as a Boulder resident, I'm here to share my concerns about Creststone's comprehensive drilling plan, which casts serious doubt on their ability to conduct drilling in a manner consistent with protection of public health, safety, and welfare per the charge of the COGCC. Creststone has failed to address numerous inadequacies identified by stakeholders, including not identifying freshwater sources or demonstrating the scope of mineral rights ownership or identifying measures to protect sensitive animal habitat surrounding the Panama Reservoir. So approval of either of the sites with 56 wells, and that's CPR Unit 36HM269 and CPR Unit 3HA169, those would constitute the largest and most intensive drilling operation in the state on or nearby to environmentally sensitive land that is also bald eagle habitat, so I'm very concerned about that.
Some of these proposed wells lie on land on which Boulder County holds a conservation easement. Per Boulder County's analysis of the law, Crestone Peak likely doesn't have the necessary lease rights to implement these drilling plans, and it would be irresponsible for the COGCC to approve these permits before the issue of rights ownership is resolved. I'm also here speaking on behalf of 350 Colorado, which I know you've heard from me. I think this, similar to County Commissioner Jones, this is my 6th time appearing in front of this commission. I hope that it will be the last and that change is truly afoot. But I'm here speaking on behalf of 350. It's a nonprofit focused on solving the climate crisis. Thank you. I'm here once again to impress upon you each to protect public health and safety first and foremost, to urge you to pause the approval process for the plethora of pending permits submitted before the elections. We continue to call for greater protections of health and safety for communities and an end to the overreach of oil and gas in our state. We're calling for change and reform. We want people, communities, public health, safety, and the environment more properly protected and prioritized. Our current rules are outdated. They must be changed to clearly state that health, safety, and our natural resources should be prioritized first. We're concerned that the COGCC has continued to overwhelmingly ignore and dismiss our complaints regarding air quality concerns, water quality concerns, health and safety concerns, concerns over fires, toxic spills, accidents, and overwhelmingly siding with the oil and gas industry. Since the November election, we've had at least 3 major fires and explosions at oil and gas sites in Colorado, and 27 Western Slope elected officials have asked for increased air quality regulations. So change and COGCC reform is long overdue. We call on this commission to do its part to adequately protect Coloradans and our beautiful state. Thank you very much for your time again.
Mr. Purcell? Terry Bennett, John Bennett, and Kevin Kraus, please. John and Sue Garrett. John Richard. Edward Granados. Edward Ingby. Janice Howell. Vince Miller. Gina Harden.
Hello, Commissioners, I'm Jenna Harden, and I'm here as a mother, grandmother, and president of 350 Colorado, which represents some 16,000 Coloradans dispersed throughout the state. I'm also a homeowner, property owner, and business owner, concerned about the financial well-being in the state, and a mineral interest owner who has been denied the property right not to develop my oil and gas interest. This first responsibility of the state government is to protect the health, safety, and welfare of its population. The COGCC has regrettably chosen to expend its power to defeat this first responsibility in favor of oil and gas interests. The people of Colorado have responded by demanding that the priorities of the COGCC be clarified and realigned. Despite the oil and gas interests and the oil and gas industry's expenditure of $40 million to confuse and obfuscate. The legislature is finally attempting to align the law to fulfill its first priority. Of course, the oil and gas industry is continuing to expend its considerable resources to confuse and obfuscate, and is submitting a record number of permit applications to defeat the legislature's attempt to fulfill its first responsibility. Of course, the COGCC has the power to continue to sacrifice the long-term health and well-being of the people to oil and gas industry's interests, or to pause the granting of permits until the legislature has done its work to hopefully honor its first responsibility to the people protecting their health and safety. 350, I'm not sure what that means.
It means your time is up.
Okay, we urge
You can
you.
just wrap it up.
Okay, thank you. 350 urges COGCC to honor its first responsibility and to pause the granting of permits until a legislature acts to protect your health and safety. We also urge you to enforce pooling, which prevents responsible people from choosing health and safety over their own financial benefit. Thank you.
Edward Ingby.
Caught me coming through, maybe I wasn't quite ready, I'm sorry. Well, I'm back. Once again, I'd like to bring before this commission the issue of the Third Creek, Anadarko shutdown, kind of out in the Adams County, Arapahoe County, Over County areas again. This was a monopolistic system. There is no other alternatives out in this area. And Anadarko has chose to shut it down, even though there were ample parties interested in pursuing the purchase and operation of this system. This system has approximately 500 wells behind it, give or take. I don't know, we haven't been able to tie down that number exactly, of which I would say more than likely hundreds are going to end up in the Oil and Gas Commission's lap in the form of orphaned wells. The system was viable for the stripper production that was out there and the producers. And the nature of the way that it was shut down, I think is, in essence, because Anadarko was worried about liability affiliated with the system. Whether that be in light of Firestone, millions, tens of millions, I don't know, but it's going to cost the state now certainly tens of millions of dollars to plug these orphaned wells. And I just would like to see the commission act on it under the provision of the waste element of it, the impacts of this system and what's going on out there. The economic impacts are probably hundreds of millions of dollars. And I just feel that, as a duty, as a commission, your duty is to prevent waste. And I just, for the life of me, I can't understand why this hasn't been deemed waste. All we've gotten from the commission in Anadarko is this letter, and I can tell you it's chock full of misrepresentations and things that are not accurate. And I just believe that, as a commission, given the impacts to the state, there is probably an obligation here to try to get Anadarko to explain themselves. And I just wish that would be pursued. Thank you. Thank you.
Mr. Chair, I don't have anyone else on the online sign up or on our sign up sheet at the door today. There may be people, I just have the sign up sheets that I have right now. If there are more people on the sign up sheet.
I signed up online. I have a confirmation from online.
Okay, I apologize.
No problem. I mean, we certainly have lots of time to hear everyone. And I think I request to Mr. Davenport and Ms. Larson that folks that show, if we call names today, if they happen to show up tomorrow, let's make sure we give them the opportunity to speak in case either time or location is an issue as far as people being able to. So if everyone raise your hands again, please. Don't have to stand up. When we get 1, 2, 3, 4, we'll just, there's 4 seats. If you all 4 just want to come on up, we'll. Thought there was a 4th. Anyone else want to speak? It's not. Very well. We'll start with you, ma'am. Just again, and please give us your name, and we've got a couple of minutes.
My name is Janice Brown. I'm a retired nurse. I want you to know that the oil and gas workers are being paid to come here and speak at the COGCC during public comment, the same way they were paid to come to the Capitol last Tuesday to protest SB 181. This should prove to you that they are in fact not the public. They are employees and should not be allowed to speak during public comment periods. They are employees of the industry being regulated who are clearly compromised in their support of their employers. We have repeatedly been told by scientists that burning fossil fuels is the cause of climate crisis we are living in. Yet you continue to issue drilling permits. Why? It's time to leave the fossil fuels in the ground. For those of you living in Will County who want to keep drilling, you need to find a way to keep your air up there because it's polluting my air down here, the air that I breathe. Since everyone who lives along the Front Range shares the same air, this is a problem for our health and safety. That should be the priority. There are more important issues than money. It's time we quit subsidizing the fossil fuel industries. If we allow the fossil fuel industries to continue climate disruption, all the money in the world is not going to matter because Earth will no longer be a livable planet. Please pause the permits.
Thank you.
Thank you.
Mr. Boyo, and seeing how few people are here, I wonder if I might have 3 minutes.
Certainly.
Well, at first, let me start out with a compliment.
How about starting out with a name?
Okay. I'm Wes Wilson with Be the Change USA, a small nonprofit here in Colorado. Let me start out with a compliment to the Commission with respect to fines imposed for mechanical integrity test failures. Dockets number 87 and 88, a fine is going to be given to extraction of some $800,000, and to Cresto of about $140,000. But it's a violation of the most basic testing, just the mechanical integrity testing at the wellhead before it comes online. It should tell you there's a need to catch up with modern testing technology. And with respect to testing, one of the first items in the staff report talks about gas leak detection, the workshop that's going on there. It has an odd phrase. It talks about under the regulatory environment, primarily the Air Quality Control Division, that the operators have the responsibility to approve a substitute test method. But the inventors of the testing methods have most at stake. I submit to you, it's us citizens who have the most at stake here. And technology has matured. EPA put out reports in early 2017 describing leak detection using laser technology, some of which can provide us with the important species, important difference between which organic chemicals are coming off these leaks, particularly identifying benzene, which is far more toxic at parts per billion than the other volatile organic compounds. And finally, I want to bring to your attention, as if Director Robbins isn't met on his plate, problem with underground gas storage. You know, there's 11 major underground gas storage facilities here in Colorado. Some of them using wells drilled when I was born. There are 1949 era wells used to inject into these 11 underground storage locations. And of course, we don't want to repeat of the disastrous situation that occurred in Aliso Canyon in California. That needs to come under your purview or some other part of the government, It's my understanding that it's not adjournment, and so on. Then finally, let me turn to EIA reported in 2017 that some 4,280 million cubic feet of gas was wasted on your watch. It was come from venting and flaring of oil and gas facilities in the state. That's about $13 million worth of gas going up in flames and not being developed. You can easily slow down these wells until there's pipeline capacity available to provide that resource and get the tax revenue from that. Thank you.
Thank you, Mr. Williams.
Good morning. I'm Jessica Abel. I'm an American Baptist preacher, so I'm not going to ask for more time. You're going to have to probably waive that 30-second turnaround. Apologize in advance. I am the Colorado organizer for Green Faith. We are an international coalition of interfaith voices calling for a different way of even thinking about this. That our relationship with creation and nature and with each other is part of our sacred stories of all people of faith, even if we don't have a specific faith we identify with. One of the great secular environmentalists, for instance, John Muir, called nature God's cathedral. And so one of the things that we bring to the table is a reminder that there are other and fundamental things happening. I respect and hold as important, for instance, workers and industry, but I think we've all bought into a false dichotomy. For instance, in her book, The Soul at Work, Margaret Benefield reminds us that oxygen fuels our blood and is what makes us run the same way profit is what fuels industry and makes it run. That the point of business isn't to make money any more than the point of life is to breathe. We've really missed some fundamental things. And in the church institutional that I have represented in my past, and sometimes simply by wearing this uniform, we've certainly screwed things up by letting go of our fundamental call, our fundamental understanding of who we are. Thank you. And instead, gone with the policies of allowing something simply because it was allowed. Sometimes we have to slow down in order to change. The world is changing around us and there's a lot of fear. And y'all's charter's about to change. Things are happening all around us. Green New Deal stuff is swirling. Everything is changing and it's hard to come from a place that isn't a place of fear and everything. So I just want to remind you that you too are part of creation that needs to be saved and held in stewardship, and that that's part of all of our call, and that we can choose to live.
Thank you, ma'am. I think that's everyone, unless there's anyone else that happened to walk in that would like to speak this morning. All right. Commissioner Gibbs, would you like to do your executive director report prior to the break?
Sure.
Thank you.
Yeah, thank you, Mr. Chair. And then, first of all, I'm Dan Gibbs, the fairly new Department of Natural Resources Director, and looking over at my fellow executive director, Director Jill Ryan. I think we've been sworn in about a little over a month ago or so. So very busy structuring all the different divisions. But before I jump in with the DNR, I'm just so happy to see a almost full room here of folks that are weighing in on important issues to them. I'm a former county commissioner, was elected 3 times, so I understand the value of what happens in folks' backyards. So I'm just happy to see the folks here in general. Few updates for me, staffing updates. I'm without a Colorado Parks and Wildlife director. Right now we're doing a national search and that's going on for about 3 weeks. So that will close on March 20th. So we really hope to have some really wonderful folks apply for that important position. We're also doing interviews this week for communications director for Department of Natural Resources, and hope to be able to make a final decision by the end of this week. And so that's important too. Also hired a new deputy executive director, and that person will start on March 18th. Hired Tim Mock. He formerly worked for Congressman Mark Udall in Washington, D.C., worked for Andrew Romanoff as one of his policy directors, and he was Speaker of the House, and also he's a two-term county commissioner from Hickory County, so someone I've worked with for years that I think will do a really wonderful job for the state of Colorado and the DNR. Some other updates, where I live in Summit County in Breckenridge, we've received 89 inches of snow over the last 10 days, believe it or not. And some of the folks that have traveled in the high country know darn well it's been a challenge to travel because a lot of the avalanches and so forth. So one of the divisions I have oversight is Colorado Avalanche Information Center. So that division has been working extremely hard to make sure roads are open throughout the state of Colorado. We have seen and observed 40-year avalanches and some documented 70-year avalanches, which is really just unprecedented. Let's see, water issues update. We are currently working on a 7-state agreement to look at drought contingency measures for Colorado and the 7 Colorado Basin states. That is really thanks to the Bureau of Reclamation that said, hey, 7 states within the Colorado River Basin understand that, hey, we may have decent snowpack right now, but we have a historical trend of dryness. And this is, in my opinion, big picture topic of looking at, climate change and making sure that we're preparing for less river in the Colorado River. So Colorado passed its updated drought contingency measure last December, but we're still working on Arizona and California to update their plans. So we're optimistic that they will come together and we can have a 7-state letter that will be brought forward for the Federal Registered Notice that the Bureau of Reclamation brought forward. The governor has 4 major priority goals. I just want to make sure that everyone is aware of those goals too, because it doesn't matter what department you're in charge of, we are working hard to implement those goals. And number 1 is implement free full-day kindergarten for all. Number 2, reduce the cost of healthcare insurance. Number 3, set Colorado on a path of 100% renewable energy by 2040. And number 4, reduce the income tax rate for Colorado residents. So those are 4 major goals that the governor has for the state of Colorado. And again, as a result, all divisions are really working towards those goals. Let's see, Mr. Chairman, you should probably give me the hook because I can probably talk for a long time, but I think that may be good for right now.
I usually have as much time as.
Oh, do I? Oh,
yeah. Well, we might have to, we might limit the acting director to go right ahead.
Just maybe just a last update. Obviously the legislative session is ongoing. There are many different bills that the Department of Natural Resources is following, and we are supporting some and opposing others. Some folks mentioned the bill that was introduced last week. The governor is very supportive of Senate Bill 181. I testified in support of that measure, and the DNR is also taking a position in support of that measure. I guess that's it for right now.
Thank you, Commissioner. We probably have time if you'd like to go ahead.
Sure, thank you, Chairman. My name is Jeff Robbins. I'm the acting director of the Colorado Oil and Gas Commission. I too am thrilled to see a good group of people in this room, in a little larger room to try to accommodate our hearing today and tomorrow. It's exciting to see folks that are here to participate. Just in terms of, we have our staff report that we put together. We can take questions on that from myself or from staff. I wanted to focus a little bit on the director review criteria that we put together. We spent time, so I've been on board now about 6 weeks. Within the first week or so, I learned a lot about permit review and the process that undergoes here at the COGCC relative to the 6,000 or so permits that are in our hopper. Met with my staff and sort of walked through that process. And we decided that it made some sense to create a system of criteria that would sort of be a prism in terms of how we're looking at 2As and 2s. And 2As are the oil and gas locations, and 2s are the actual wells. We implemented that on within a week or two of my being involved. What it does is so the way that permits are reviewed at the commission is we have a team of permitters, and they look at it from various sets of prisms in terms of ensuring compliance with our regulations. It works through the process, and it ultimately gets to a permit reviewer that has the ability to approve permits. I wanted a additional level of review for permits that met certain criteria, so that we were making sure that the director was able to take a look and ensure compliance with permits that met that criteria. This has been working. We have, in the past month, worked through many of the 2As that are in the process. We have, as of I think today, and Greg can help me, Greg's going to come up and do a quick little slideshow. Greg, if you want to go ahead and get ready for that, that would be great. But we had 511 2As in process over the course of the last month. We have approved 48. Of the permits that we've reviewed over the course of the last month, 23 were flagged for additional director review. That generally encompassed an additional week or so of review, so that we could look at the issues. Of those 23, 22 have been actually approved, and 1 remains subject to some additional review. With that, I'm going to have Greg sort of walk you through. This is a PowerPoint that we put together. We meet monthly with our operators in a monthly operator meeting. That meeting is open to the public, and anyone can attend either in person or online via telephone. And it was probably the first week of February that I met with the operators and provided this director review criteria. I've also met with most of the operators in the state of Colorado. Well, let's say it this way. I've met with all the operators that have asked to meet with me. And there's still a few that we're trying to set up meetings. Also, I've been meeting with stakeholders. And in those meetings, I've informed everyone that this process is to be considered fluid, and that we're going to continue to massage the director review criteria. Last week, we reduced the criteria from 19 down to 15 because we decided that some of the criteria weren't quite as necessary. And so with that, Greg, do you want to work through briefly the 2 and 2A slideshow we put together? This was put together, I think, originally in early February. Is that right?
Yes. Good morning, Commissioners. Greg Durrell, Environmental Manager at COGCC. Yeah, you're correct, Director Robbins, that we put this presentation together and delivered it to what we have a monthly operators meeting where we give policy and process updates to regulatory staff at many operators, many participating operators. Looks like we've got some technical difficulties, so hopefully the visuals will add up. And as Director Robbins said, we did modify the criteria slightly as we've worked through these and determined which ones were having an impact and which ones were maybe not necessary to add as flags. So I walked through the process, sort of the purpose, process, and criteria pretty quickly. And again, this slideshow is pretty much the same thing we delivered to operators on February 19th. With the administration's focus on protection, as Director Robbins said, we wanted to make sure that we were identifying high-profile locations as that process, as the technical review process played out, and ensuring that there are all appropriate measures that staff is able to place on their permits with best management practices, conditions of approval, and technical evaluation are being done as part of that process, and more than being done, also well documented on the 2As. Primarily, we're looking at Form 2As, although we are also looking at Form 2s. The 2A, the oil and gas location assessment, includes information about the individual wells on a pad. The Form 2s, however, are sometimes submitted independently for either a refile application when the APD or the application for permit to drill has expired, but the oil and gas location assessment is still valid, or it's an existing location. Also, if let's say an operator applied for a pad with 16 wells on it and submitted 8 APDs for that well, and then they come back to submit the other 8, they wouldn't necessarily need another oil and gas location assessment at that time. So we're looking at those 8 APDs when they come in as well to make sure that we're catching everything. So the process is the oil and gas location assessment specialist is sort of the primary driver on this, and they look for the criteria, flag the permit, and then it gets sort of set aside in a batch that we review directly with Director Robbins as we go through and move towards approval. The process right now is that many of the applications that we've been looking at in the early implementation of this process are already nearly complete as far as the technical review, and they are ready for final director approval and signature on the permit. They've been deemed as a legal permit that meets the criteria of our rules, and yet we're still looking at them and bringing them up for discussion with Director Robbins and looking at things like, hey, there's a proximate local government there. Did we have a conversation with that proximate local government? And whether or not that conversation may have happened in the past, it wasn't well documented because it wasn't a requirement of the rule. So now we're following up on those, on issues like that. We're having that conversation with the proximate local government. We're documenting that in the permit. So where we were is the technical review had been complete, and then we were asking whether or not this permit should be flagged. If it was flagged, it gets kicked over for additional director review, and then based on his review of the application, is it good to go for approval, or do we need to circle back with the operator with maybe a public comment or something like that, and then that process would go back to staff to finalize, and then it would come back once there's resolution. It would come back, the director would look at it again. Great, you talked to the local government. Now we've got that documented on the Form 2A. We can say that's good to go and move it through to final approval. What we're trying to do is we're trying to shift this process earlier in the technical review process so that it's not happening at the very end of the game when staff has already gone through a 30 to 75 to sometimes longer day process to get a permit ready to be approved, and then we're kind of putting this hold on at the end. So the earlier we can get through this this additional review process, the less likely there are for delays. We are currently processing operators' permits due to the large backlog based on a priority system, where the operators actually tell us, here are our highest priority applications. These are the ones that we've got a rig on the schedule. We want to get these going. So we are trying to work this process into that process, join the two, and make sure that we're still providing a timely and appropriate review. There you go. I just mentioned the priority list, so that still remains the way we are ultimately cycling the permits through. This process does result in a small delay because obviously Director Robbins' time is occupied by many things, and so we've scheduled a once-a-week meeting with him to kind of go through these flag permits.
And just on that point, we've actually been trying to meet twice a week just because it's necessary in order to get through these. And so we're trying to meet at the beginning week and then sort of toward the end of the week. For instance, we were supposed to meet at 9 this morning, but we had other things, and so we'll do that later.
I was just gonna say, we could go through a couple. So now getting into the criteria that we're looking at. And these are things that we've, been addressing throughout, the oil and gas location assessment process. But it's getting these items highlighted, getting them in front of Director Robbins and having further discussion about it. So locations within 1,500 feet of a residence or high occupancy building unit. Obviously, we have setback criteria based on 200 feet, 500 feet, 1,000 feet. So this 1,500 feet is giving a broader look. Let's look out a little bit further and look at those ones that are maybe on the margins. If you get a lot of applications that are 1,001 or 1,020 feet, hey, let's take a look at those and are we applying best practices that we can. And when I say BMPs, best management practice, when I say COAs, conditions of approval, I'm sorry for using that or initialisms. So locations within a municipality, obviously, municipal boundaries, and that's, a big concern with local control. We are looking at that. We're making sure that the local government, if they municipality documented back to us that, yes, in fact, the operator did reach out to us. We had a concern about their original traffic route. It was on a low weight road, not a high weight road. And so they had worked with the operator to get an alternative haul route through their community. And, so that work had been done on the front end. It wasn't documented on our permit because it wasn't a requirement of our permit. We got that documentation, and it was really good to see that, the local government, the proximate local government's concerns have been met. Obviously, any locations that are urban mitigation area or large urban mitigation area facility are certainly getting flagged. Locations within the school setback area would be getting flagged. Locations within floodplains, public water system protection areas. We have Rule 317 Big B, and we have an order from the commission surrounding the Bradenhead public water supply protection. Those are getting flagged. Specific sensitive wildlife habitat and restricted surface occupancy sites are getting flagged. And we've probably been more liberal with this than just those two species. We've actually brought most of the RSO and sensitive wildlife habitat sites forward. Locations to be operated by an operator that's subject to additional bonding requirements, and that would be under our Rule 702, where we have reason to apply for a higher level of bonding based on operator performance or financial situation. Locations proposed within an exception zone location, that's within 500 feet of a building unit. Locations added by the director, the executive director's office. So if something is rising up through public comment, through other channels that aren't necessarily coming through our permit process, we're getting a look at those. Right to construct is a surface bond. Operators are striving to work with surface use agreements. We certainly encourage working with surface owners, but sometimes they wind up bonding onto a location based on their either they haven't successfully negotiated that surface use agreement or there's some sort of conflict there, so we want to see those. Comments from local government, state or federal agencies, including wells with a consultation with Colorado Department of Public Health and Environment, through the oil and gas liaison there, through Sean Hackett. Any of those wells get flagged. Applications that have received comments from an environmental group or homeowners associations, or other groups raising concerns. And again, we've kind of treated that liberally, and we've basically anything right now that gets, a good number of public comments on it, or a few public comments that are very specific, we're making sure that Director Robbins is seeing what kind of comments are coming onto our permits. Applications requiring a 502B variance. So if the operator does need a variance in order to get their application, obviously the director grants those variances anyway, so that's sort of redundant to our processes, but we want to be very transparent that those are getting done. Also, many, a variance might trigger a CDPHE consult as well, so it might check several boxes. And that's really all I've got on that process.
Just to follow up, we'd be happy to take questions. I had 4 sort of final points on this whole thing. One is I want to express my appreciation to staff. They are doing a marvelous job of working in line with the direction that we're receiving from the administration to elevate and balance environment, health, safety. We're working under the current protocol, and we're trying to establish the right balance to ensure productive natural gas and oil mineral resource development, but with this prism to make sure that we're doing this in the correct manner. And I really applaud staff's stepping up and working with us. Greg, you've done a great job, as have your team. I really appreciate that, as well as the rest of my management staff has been excellent in looking at this. So that's point 1. And point 2 was sort of, that we're trying to strive to create this balance. I also want to thank many of the operators that I've talked to about this are sort of looking at this, and they're sort of proactively engaged on this front at this point in time. And they are taking a look at their permits and their 2s and 2As and trying to sort of establish that these things that are on this list, that they're good to go, so that we don't have to sort of circle back. And then the other thing we're doing is, as Greg pointed out, when we first arrived, it was sort of, we're kind of jumping into this sort of, it's already ready to go, and we're taking a look, and we're trying to move that look earlier in the process. So probably take that look at, right after public comment. And then I guess sort of the final point I would make is the current criteria and the current protocol. There is no criteria or protocol that speaks to hairy or sticky wells anymore. So we've removed that verbiage. We think that we've got a good set of criteria that's working. And so with that, I guess, staff and I would be happy to take questions.
Mr. Blaine?
Thank you, Mr. Chair. Just working. Great. So first, I want to commend Acting Director Robbins and the staff for doing this. I think it's a significant step forward. It's very useful to have orderly process as part of this entire review structure. And I think it will enable us to get a much better handle on the substantive issues. And I'm glad to hear that operators are responding positively and working constructively with staff, as you said, proactively, to make sure the system actually functions the way you're intending it to. So I'm pleased about that. What I wanted to focus on was the whole public comment piece of it. One of the themes that we've heard in recent months is that the system is confusing. We tell folks that the time to express your concerns and to comment on questions involving public health, safety, and welfare is at the Form 2 and 2A stage, not at the application for spacing unit stage or at the pooling stage. Those are different matters that don't involve issues of public health, safety, and welfare. That's what we tell them. Then you have the permitting process initiated, and we're hearing from folks that it's confusing how they're supposed to comment, how they can get their concerns into the record. There is a fairly tight time frame. It's 20 days after the permit is posted. Not everybody's aware of that, and I suppose one can say that you've got to be aware of what the procedure is, but nevertheless, it's a fairly restrictive procedure. And what I'm hearing from you is that the public comments that you're receiving are the trigger for the application of a significant number of these criteria. You're trying to deal with it at an early stage, which is great, and public comments are the way to do that. Make sure you hear about the concerns that organizations or folks have. But nevertheless, there may be comments that you're not getting at that stage. For example, you talked about criteria that might include concerns expressed by the governor's office, which presumably would be triggered by concerns expressed to the governor's office by interested parties, which could occur after the public comment period has ended. So all that's a pretty long-winded way of asking you to comment about your thoughts on the public comment process and how comments should be taken, whether there should be some kind of a time frame, time limit, and whether the process for making sure the public understands how to make comments is well understood. So basically, it's a broad-ranging question about comments.
Thank you, Commissioner Boygan. Yeah, I think that's a area that deserves some additional attention from me as acting director as well as my staff. I think that our rules provide that certain folks would receive comment, and Greg, I'm kind of defer to you because you've got a better understanding of this. But it is likely that it would be helpful to the public at large to, I don't want it to be confusing. I want it to be, I want us to get to a point where it is very transparent that a well location is being looked at and folks can know about that and folks can talk to us about it. That's where I want us to get. And I'm not sure that we're at that spot yet, but that's where I, as acting director, would like this to get to. I would like it to be a transparent process at every turn. Transparency for operators, transparency for the citizens, so that we are doing, because the very best job that we can do is going to be the job that's informed by the public. And so, Greg, I just sort of turn to you. I know that some folks get like notice, but I have a feeling that the sphere of what that is, maybe not where we would like it to be, and perhaps we can look at that. But could you speak to that a little bit?
Sure. So all applications that are submitted to us within a buffer zone, so within 1,000 feet of a building unit, require notifications to the surrounding building unit owners. All local governmental designees get a notice of applications within their jurisdiction. Many local governments have also taken to, creating like an oil and gas webpage where they're also posting those things. All the applications are posted on our website. Under our permits page, if there's someone interested, if they know of a permit nearby, if they're interested in making a public comment, they can go to our permits link and search by county for active applications and click on a link that gets them directly to a comment portal. We upgraded our comment portal to make it more user friendly. And those comments get posted directly onto the Form 2 and 2A. We have had some cases where folks have had challenges making comments through a portal for one reason or another, And we've accepted those in an alternative fashion. Ideally, if they come through the portal, they get posted directly on the application, and that's really the best and most transparent way to do it. In the past, we had problems with mobile phone applications, and I think we've got that resolved. So they could get to that link on their mobile phone and get a comment to us. We have applications that receive hundreds of public comments. We have applications that receive 2 or 3. We have applications that receive comments from local governmental designees. So while we know there are some hiccups with it, we also believe that we're getting, pretty good comment. It's not, someone has to be paying attention to the fact that they're in an oil and gas basin and there's oil and gas activity going on. If they're outside of that 1,000 foot buffer, they're not going to get a letter that says, hey, there's oil and gas coming to you.
So again, I'll take that as direction to sort of relook at that. And again, it only helps the process if we've created a transparent situation so that people can become aware of potential oil and gas and provide comments to our staff so that we can, look at it through that prism. So I appreciate those comments.
Can I add one more thing? And that's just that all of our pending applications are also posted on the COGCC GIS online maps. And so if a person knows their own street address, they can plug in their street address, zoom into it, and they can look for pending applications around their house, or maybe it's around their school or around where they work. And that's a really valuable tool. From there, they can get the document number and then go to the permit page to post public comment.
Thank you. I would comment that mapping tool is very useful and fairly intuitive to use. So, a lot of credit goes to a lot of work that went into creating that mapping tool. Commissioner Gibbs?
Yeah, thank you, Mr. Chairman. I would just like to add that another of the divisions that are part of the DNR is Division of Reclamation, Mining, and Safety. And we have put forward something very similar to that permitting actions that require director notification. So let me just rattle off a list. It's everything from permitting action that's received significant comments from local, state, or federal agencies, permitting action that's received any objection, mining activity that's within your stage routes or other critical wildlife areas, mining activity involving possible impacts to wetland, floodplain, or stream buffer zones, mining activity involving possible disturbance of hydraulic balance. There's 13 different new criteria within this, so I just want to make sure everyone knows it's not just the COGCC, but it's also Division of Reclamation, Mining, and Safety too. They're doing almost very similar to identical measures.
Very well.
Mr. Chairman?
Yes, Commissioner Overton.
So I want to echo what Commissioner Boyd said, which is that I think it's a great undertaking, and I'm very pleased that it's underway. I guess one question that I had was, it sounds like you've gotten some positive feedback from the operators who have been involved and have been brought up to speed on this new process. And I wonder if you've received any feedback from community groups, adjacent local governments, conservation organizations, or those types of entities who may, and what their reactions to this additional process have been.
Frankly, I have not heard comment, positive or negative, from those sorts of groups. It's hopeful that they view this as a positive turn, because it is, bringing their comments, and their comments are one of the criteria that's going to make sure that my eyes take a look at a proposed location. So I also have not had as much opportunity to interact with those groups as my time is very full these days.
Very well. By the way, welcome, Commissioner Hunsaker Ryan. This, I think, is your first hearing. Thank you. Yeah. No, we won't make you make a seat, unless, of course, you'd like to. For that, I think we have time for a break. And I believe a little bit, we had about a 10-minute break scheduled, so we'll shoot to try to be back here about 9:30. 10:30, sorry. Looking at the clock.
Ms. Larson, I believe you're up.
Thank you, Mr. Chair. Yes, I just have a few brief comments to provide the commission. So, as I've provided in the past, at the January hearing, I advised at that time that we were down one hearing officer and we're interviewing for that position. I'm pleased to announce that we've made an offer to a gentleman who applied for the open hearing officer position. He is accepted. He will be starting on March the 25th. So we will be at full capacity, fully staffed in the hearing unit for hearing officers. He comes from the There we go. The hearing officer is currently an attorney advisor for a federal administrative law judge who specializes in MSHA, Mine Health Safety Act matters. So he will be coming to us, as I said, on March 25th. So we're looking forward to that. I also noted earlier on today that the hearings unit is working on several documents that will provide guidance and greater explanation to the public as to what our process is. Certainly for members of the public who are not represented by lawyers, it can be very confusing, our process, and we recognize that. And the hearing officers always do their best to work with members of the public and provide them advice as it relates to our processes and guide them through that. But being able to go online, find a document that plainly articulates what we do and how we do it and how they can participate is key. And so we're working on getting that document put together and posted as soon as possible. I also wanted to let the commissioners know that we, for this hearing cycle, have implemented the training docket. That was an idea that was brought to me by Hearing Officer Rouse as a means to hopefully make sure that we don't have gaps in the agenda, because what we will frequently have is we will notice 4 or 5 matters for hearing. 2 or 3 of those matters need settled, and then we just have a lot of dead time for you guys. So what we saw in this hearing cycle is we had about 3 weeks ago a really healthy and robust agenda with a lot of protested matters, and within about 4 days, 6 days before this actual hearing, 4 of those matters were either continued or they settled. So as a result of having this training docket in place, we were able to slot in other matters that were protested and were ready to go to hearing. So we're happy that this system is working. There have been a few bumps along the way, but we're getting through that, and we hope for the April hearing to also have that system going. So we'll have a large number of cases that are ready, briefed, can be brought to you if, in fact, we have matters that settle. So other than that, I'm happy to answer any questions anyone may have, but that's all I have for the update.
Yes, Mr. Williams.
Just a brief comment. Thank you, I really appreciate that report. It actually is some of my commissioner comments. And I'll just make a comment, and maybe you can treat it as a question if you want. But we need to be working on how to make our system more user-friendly. What we talked about a few minutes ago about comments on permitting applications in one area, pooling is another, where we have people who are brought into the system sort of involuntarily, if you will. They're not forced in the industry. They don't necessarily understand the process. We need to think about how to make the system, as I said, more user-friendly and workable, so that normal people can participate in it. What their rights are, and don't necessarily need to go hire lawyers in order to participate. Not that I'm saying hiring lawyers is a bad thing.
Speaking as a lawyer.
Right? But we need to make the system more workable.
And I believe we have a link to some different documents about explaining how the pooling process works, I think, on our website already.
That's correct, sure. We do have the pooling pamphlet that is available that seeks to explain in layman's terms what pooling is, what the process is. And that is definitely one resource the public can consult. What we would like to be able to do is build on that and to provide the public with also sort of a step-by-step process and explain to them, as we heard from the woman this morning who said, well, I received this notice and it said you're going to hearing on March 11th, 12th. So naturally, one would think they need to be here on March 11th to have their matter heard. So, being able to walk folks through and advise them what that looks like and how the pre-hearing process works. And if you haven't gone through the pre-hearing process, your matter's not just heard. Things like that.
I think, and I believe there's at least a couple of other commissions, I think Wyoming or maybe North Dakota also has some different. That may be useful just to even put links out to those two sites as well.
It's always good to look at our sister states to see how they have already done a good job and we can copy them. So thank you.
All right. Thank you very much. Commissioner Overture.
I just wanted to follow up on that conversation and the comment that we received from, I believe it was Liquid earlier during public comment. I recognize this is yet again one of those situations that could be made easier once we get an e-filing system in place, and so I would welcome an update on where we are with that. But I wonder what the process is. It seems to me that once someone has filed a protest, that they should automatically be getting notice of any communication that's occurring between the operator and the commission, and probably vice versa. And so I wonder, does that happen? If not, is there a way to have that happen in the absence of an e-filing system? I don't know under the current practices of the hearings unit, whether when a member of the public files a protest, whether that is even communicated to the operator. I assume it is, but I don't know for sure.
Yes, thank you, Commissioner Overture. So I'll take your last question first. So as it relates to protestants, once someone files a protest, they are going to be included on all communications that transpire among the parties. So the applicant will be notified of the protest. The hearing officer, once he commences the pre-hearing process, is going to ensure that they receive the protestant and the applicant are all in the same email communications and receive any and all communications that may come from either the hearing officer or the applicant. The applicant must also ensure that they're copying protestants on communications to the hearing officer. Once a matter is protested, we are diligent in ensuring that we're not having ex-parte communications. So and that's something that we seek to explain to protestants that are not represented by counsel, that if they just reached out to the hearing officer and failed to copy the applicant and their counsel, we advise them that, going forward, they must do so. So then as it relates to the electronic filing system, I've been working, and John Peskin, who is one of our hearing officers, have been working with our IT staff, and we delivered to them last month the final proposal for the e-filing system, and the IT staff is diligently working to build that. And right now, I don't have an estimated timeframe as to when that will be completed, but it is a top priority for them, and they are working as fast as they can to get that going.
Mr. Gelling.
Secretary Larson, now that we're getting to full staff, can you address or maybe anticipate some progress in the backlog of general administrative payment proceed, those types of cases? Not necessarily, I know there's a lot of applications, but the other things that have just kind of been languishing there, can you address what progress you anticipate there?
Most certainly. So the hearing officers are attempting to make the general applications not protested matters as higher priority as the protested matters. I will tell you, for instance, this hearing cycle, one of our hearing officers, Michael Eden, was taken off. Well, I shouldn't say taken off. He had much of his work schedule devoted to two highly contentious matters that you'll be hearing tomorrow. So for about 3.5 weeks, that was more or less his full-time job, just working on those matters. Even with that, and then getting another matter that you're going to be hearing this afternoon, prepared for hearing. Even with that enormous workload, he was able to get many consent agenda matters ready for you.
The other hearing officers are in a similar situation in that they're trying to balance the protested matters with the general consent applications. We certainly do anticipate that with the new hearing officer coming on board, that he will be able to jump in and start assisting with clearing that backlog. Recognizing, however, while he was an intern at our office when he was in law school, he has not practiced in the oil and gas world. So he will take, some time to get trained up and to become familiar with this process, which will take time. But that's not to say he won't be working as soon as we possibly can get him working on the agenda.
Are you saying that it'll be the new hire that will be dealing with the old cases?
We'll have to look internally to see how that shapes up. Certainly, we want to ensure that the new hire is able to assist with us as much as possible in clearing the backlog, and recognizing that we have 3 skilled and experienced hearing officers who can also work on that and are working on that. So we'll just internally have to look to see what that looks like.
Thank you.
All right, so I know Commissioner Boyan, you have some things about the minutes, but I would like to open up this for other commissioner comments. Mr. Fonseca Ryan. I believe it is.
Okay, thank you. Just wanted to introduce myself. My name is Jill Fonseca Ryan. I'm the new Executive Director of the Colorado Department of Public Health and Environment. I have nearly 25 years in the public health field. I worked as the director of the department at Eagle County prior to being a county commissioner for the last 6 years, and then was recently appointed to this post in January. Throughout my career, I've worked at the Colorado Department of Public Health and Environment off and on for around 10 years. So I'm really looking forward to being on this commission and bringing a public health lens. Thank you.
Thank you, ma'am. Any other commissioner comments? Very well. We'll move forward with approval of the minutes. I think Commissioner Boyan, you had some comments.
Thank you, Mr. Chair. Just a few quick points that may well fall into the category of hyper picky. That's who I am. But I'm concerned about how we prevent some of this. So I'm looking at the minutes of January 28th. And on page 5, an obvious typo in the description of the penalty matter. It just says this, Commissioner Jolly moved to approve the stipulated over finding violations. Obviously, it's supposed to be order. And then back on page 2, a couple of places, I think there's something that, I don't know, garbled a little bit in the wording, but in the reference to my question about whether there was any, it says correspondence between receiving comments and the amount of time it takes to work a permit through the system. I think maybe the intent there was correlation, or it just doesn't quite sound right. And then later on, a couple of paragraphs later, when Mr. Benton asked if safety concerns are being addressed, Mr. Durano ensured the commission. I think that's supposed to be ushered. I'll try to avoid making these kinds of comments in the future, but I think it's important to have maybe a second read to catch some of this kind of stuff so that the minutes are clear. And then later on, a couple of things. When you talk about FortiGen presentation after lunch, it's at 12:40. You state the docket number, you state the attorney, you state the subject, but you don't state what happened. And it says that staff requests FortiGen to make a report. detailing its progress. Well, I think that's actually what happened in that discussion. So I'd like to see the minutes reflect that point. And then finally, later on, I can find it. Oh, I think it was the next day when we, on the Ballot Mesa permit. Yes, the next day at 4:08, it says, Commissioner Gibbs moved to have public hearing to allow the public to speak and URSA provide an alternate site. And then it says, result, 4:24, Commissioner Gibbs moves to withdraw the motion. There's no indication that there was a discussion on that issue, and as a result or following that discussion, the withdrawal motion was made. So again, I think it's more, from my point of view, I'd like to see the minutes reflect more of what actually happened, rather than just reciting that we were all here.
Thank you, Commissioner Boyd. We will make those edits and we can circulate a revised minutes to you this later today and have you vote on that tomorrow. That's acceptable.
Yeah, I think that's material, particularly with that last one, because we had a fairly lengthy discussion about Ballot Mesa. All right. Commissioner Boyd, anything on the other set of minutes? Okay. So I think we have one set of minutes to review and approve. And that is Larson.
I'm Chairman, could you please repeat that? I'm sorry.
We still have, I think we have two sets of minutes to approve.
That is correct. So if you're, would like to, you could go ahead and approve the minutes from earlier in January, or just approve everything tomorrow when we circulate the.
Why don't we go ahead and do the one from the early January hearing? I can't, if you can provide us with the dates on that,
Yes,
please.
most definitely. So the date, those would be the minutes from the January 4th, 2019 special hearing of the Commission.
All right. Would someone like to make a motion to approve those minutes?
So moved.
Motion made by Commissioner Boyden. Seconded by Commissioner Ager. All in favor, please say aye. Aye. Opposed, same sign. Minutes are approved. Thank you very much. We now have the consent agenda items next. These are just consent agenda items groups A through Q. Are there any matters here for which there is a potential conflict of interest amongst any of the questions? I am shocked. Very well. Things change. That's a good thing. At this point, hearing none, then we entertain a motion on consent agenda items group A through Q. Motion to approve those. Motion to approve. Motion made by Commissioner Jolly. Seconded by?
Second.
Seconded by Commissioner Ager. Any discussion? Hearing none, all in favor, please signify by saying aye. Aye. Opposed, same sign. Motion carries. Thank you very much. Next item is the enforcement administrative orders by consent. Commissioners, are there anything on this list that you would like to pull out to discuss separately? Commissioner Boygan.
Yes, Mr. Chair, I would like to briefly discuss the medical matter and then the three Bradenhead testing matters.
Any other matters that commissioners would like to see separated? So at this point, we would be left with, I believe, only the High Point matter to approve, because I think the last three, Crestone Peak Extraction and Cup Creek, all deal with Bradenhead.
Yes.
Good morning, Commissioners. This is Scott Schultz with Colorado Attorney General's Office. And I'm happy to answer any questions that you may have on the GetEcho matters or the Bradenhead matters.
Since it's only one, why don't we just take them each individually, and let's start with the GetEcho matter. Mr. Boyd.
Sure, thanks. This is just a very brief, highly technical question about who you're dealing with. The ALC is signed by a receiver on behalf of GetEcho. GetEcho is apparently the new operator. It wasn't clear to me what connection there is between the receiver and the operator, and who has authority to actually find whoever's being bound. Where's the money coming from? That whole track wasn't clear to me.
Right. Thank you, Commissioner. So this is an interesting matter. This is, you may have heard in the news, Jack Greinberg and the case in Arapahoe District Court. GetEcho is, and John Morgan is the court-appointed receiver in that matter for GetEcho. So there are some of the operations of Jack Greinberg were placed into this receivership, and the receivership has a fiduciary duty to the operator, and they are now the operator, and in addition has taken full responsibility for the prior issues that Greinberg had. So where it's going in the future, I can't answer. As far as what the future holds for GetEcho, that again is kind of held up in the Arapahoe District Court matter. There will likely be some appeals, but I'm happy to kind of spin this off of the Greinberg world and get this issue resolved. And the receiver team has been extremely helpful, and we appreciated their cooperation and time and efforts.
Yeah, I think that answers my question. I was just concerned, make sure we had the right parties dealing with, and that when we get a commitment to pay, it's from a party that actually has the funding to pay.
Correct. Yeah. So there are concerns as well, and thank you.
Very well. Any other commissioners about the GetEcho matter? Yes, Mr. Davenport.
Thank you, Mr. Chair. Assistant Attorney General Kyle Davenport. I just need to put on the record that I was a prosecutor on this matter when it originally began in front of the commission. And my understanding from the Assistant Attorney General Schultz is that he's contacted the various parties and ensured that there's no problem with my continuing to sit up here while you consider this matter. So.
Oh, very fortunate.
And that statement by Mr. Davenport is correct. They have no concerns with him serving as commission counsel.
Very well. All right. With that said, then in front of us would be a motion to approve the enforcement order. I thought if you're okay, we could do this, and then we'll lump the Bradenhead ones together and talk about those on the time. That's okay. I thought since there's three of those, we'll go ahead and walk our way through each docket number. Is that okay? All right. So this is just for docket number 161000377. The motion to approve the order as written. I'll move it. Motion made by Commissioner Boygan.
Second.
Seconded by Commissioner Jolly. All in favor, please see the sign saying aye. Aye. Opposed, same sign. All right. Let me check and make sure I got that correct. Yeah, next one is High Point. This is related to matter of a spill. Any questions or comments with respect to this? Very well. This would be docket number 19010018. High Point Operating Corporation motion to approve the enforcement administrative order by consent. made by Commissioner Overchurch, seconded by? Second. Seconded by Commissioner Boygan. All in favor, please signify by saying aye. Aye. Opposed, same sign. Thank you, the motion carries. The next three items are all related to Bradenhead testing. Commissioner Overchurch, I believe you said you would.
I did have some questions, it sounds like Commissioner Boygan did.
He did.
So I guess as an initial question, I think for the benefit of, thank you, for the benefit of the people in the room and the folks that may be listening, I was wondering if staff could explain what is a Bradenhead test and why is it so important that they occur and that they occur at the times that staff is working.
Yes, so this is Jeremy Farron, Enforcement Supervisor, and I will learn from the public commenter that I can hold this. You're treading dangerous water here. This is an attorney attempting to explain engineering, so I'm sure Chairman Benton will correct me if I'm wrong, but my sort of layman's understanding is the Bradenhead is the portion of the wellbore that has access to, say, an aquifer or the downhole portions of the wellbore. And it's a requirement that staff test Bradenheads on a regular basis, and they did so in these cases prior to hydraulic fracturing the well and then post hydraulic fracturing the well. And so the sort of the easy answer is it's a way to tell if your wellbore has integrity. And it's certainly an important tool that you can use to determine if your wellbore has integrity. And it keys off on a recent order that this commission implemented, which requires regular Bradenhead testing of a number of wells in the DJ Basin.
And so failure to conduct Bradenhead testing at times when they're required by the commission can lead to an oversight or a lack of information that can then create real environmental and public health and safety risks, right?
Absolutely.
Okay. And I apologize, this is Secretary Larson. Commissioner Overchurch, if you'd like, Mr. Stuart Ellsworth, the engineering manager, is here, and he can provide a little additional technical color to what hearing officer there. I did see his head doing things, so if he would like to go.
Thank you both, because I was about to throw him under the bus and bring him up here. So Mr. Elvis like it. And so Ms. Farron, that was pretty close. You did really well.
I might have said it a little different. It is a valve on the wellhead that can access the space, inner space between the surface casing and the production casing. So it's two pieces of steel. So if you had a breach, if I can call it that way, in the production casing where all the hydrocarbon fluids are coming up, you might see a pressure rise. The way I like to say it is a pressure gauge or pressure are your eyes into the hole, in the health of the hole. And if it's rising in that space, that means something's coming in. If it's falling, then something's coming away. Ideally, you want a static or constant pressure there. Colorado is a warm, the wells are warm, they're hot. So you can actually have a pressure. The point is, if it's static and constant, then that tells you the health of that well is good. The 3 times in these, we've put a lot of conditions of approval on a Form 2 that monitor that space. After you've drilled your well, cemented, you sealed it, put steel in, you constructed your well, you want to monitor it then. And after hydraulic fracturing, or what we commonly call completing the well, making it ready for fluids to flow, we want to test it there. And then we want to test it again a time frame after. So there's 3 general tests. And of course, as Mr. Farron said, you all approved the Denver-Julesburg Basin Bradenhead order where we codified that into an order.
Yeah, and so my interpretation of the orders that are in front of us for consideration today is that we then impose those testing requirements as conditions of approval of these permits, and that the operators who are in front of us today simply never came up with a plan to actually implement those conditions of approval. Is that accurate? They didn't perform the testing.
That's accurate.
Okay, so I also wonder, I know that sometimes these enforcement matters can come kind of in waves, where there's something that staff is kind of checking in on, and you go through it systematically, which I think. And so, if you can tell me, and I understand if you can't, but I wonder if there are other operators that you have found that have similarly failed to even attempt to comply with these Bradenhead testing requirements.
I believe there might be a few enforcement referrals that have made their way from engineering to enforcement. As far as I know, none have resulted in an OIV yet. So there could be more of these on the way. I mean, the engineering supervisor is not screaming at me to issue a ton of NOAV. So I have a feeling that this was the first wave. There might be a few that follow on, but I don't think that there is a second, third, fourth wave of these coming here.
So then, after asking those questions, and thank you so much for your information, just as a comment, I'd like to say that I am utterly dismayed at the complete failure to internalize and create a process to come into compliance with conditions of approval that staff placed on these permits that were issued. I don't think it's the commission's job to be holding operators' hands to ensure that they have a plan to comply with the rules that we've established and the obligations that we've placed upon operators. And so I don't have an objection to these enforcement matters, but I do want to just say publicly that I think this is a real problem, and it makes me very concerned that how do we have assurances that the conditions of approval that we place on permits are actually resulting into real life changes on the ground, that they're actually being followed, that systems are being created at the front end and not only after an NOVAV has been issued. So thank you for bringing these enforcement actions, and thank you for allowing me the opportunity to ask you some questions.
Mr. Ellsworth. Sure. Perhaps you could elaborate a bit on the importance of that Bradenhead testing in relation to how deep we have to set surface casing as part of our requirements.
Well, that's a good point. The simple answer, or the simple response I gave is pretty straightforward. It's important to remember when constructing a well, Form 2 review that we do and operators do to us, or review on their own and come forward, that surface casing, that first set of steel that's about 1/4 of an inch thick, cemented into the ground, its objective is to isolate those aquifers. So it's required to be placed below the aquifers. So those known aquifers or water barriers are already sealed off. So that's part one of the new well construction. And there's two elements of why that's put at that depth. Part one is for protection of those known water zones. Part two is what we call well control, in that when you drill a well and you drill down deeper, the pore pressures get larger, and you want to make sure you have that well in control so that you don't have what it would call, if you've got a pressure pulse coming up, fluids coming up, you don't break down at that chute. So actually, most of these new horizontal wells are actually surface casings placed well below the aquifer. Typically, kind of a minimum number is 1,500 feet. Most of them are in that general range. So they're well below the aquifer, usable aquifers, which are 1,000 or less. A lot are at 500 feet. So that's part one of the well construction. But you can get what is commonly called stray gas, little gas pockets that can flow into the well bore. They're most of the time pretty low pressure, but through this Bradenhead test, you kind of see if that, as I said before, the pressure is rising, and you're going to assume that something's coming into the well bore. So that's kind of a little bit of rambling, but is that where you were going with the question?
Pretty much, I mean, you mentioned earlier, it's sort of your window into the well, and I think it's important that that part of that aquifer protection is the Bradenhead test is to ensure that we don't have fluids that are coming up the backside of the production casing. If we have the lack of integrity on the production casing, and getting a surface casing, you'll see that through that Bradenhead test. It's part of that process of Bradenhead. The next question, I think, may actually be for Mr. Barron, or perhaps it also. I noticed in each case, and I commend Commissioner Overturf for what she mentioned about this, but I noticed that in each one of these, there were more or less was the company came up with a program after they got taken to task, and with respect to potentially other operators that may not have those programs in place, is there a process that we can share the structure of this program with some of those other operators so that they could be a little bit more diligent on a go-forward basis? Each one said, you know, this is what we're going to do now that we're going to put something in place. We've hired some people that are best management practice that we can put out there, or maybe we already are.
So my team isn't, I'm sure other people are discussing this issue with operators, but I think maybe the best way to bring this issue forward will be at the regular operator meeting and maybe highlight these NOAVs and AOCs as an example of ways to be proactive as opposed to reactive.
That's probably an excellent idea. So Acting Director Robbins, perhaps we can address that at the next operator meeting and one here in the near term. All right. Any other comments about these 3 minutes? Yes, Commissioner Boyd.
Thank you, Mr. Chair. I just want to follow up on a couple of these items. Commissioner Overturf addressed most of the concerns that I had, but I found it interesting, not in a good way, that this was coming up in a group with a number of different operators who were flagged for this, and just trying to understand if this reflected some sort of a trend or why this was happening. Why are we getting several operators at once who were having this issue? It of course triggered the question that's already been asked about, well, does this mean there are others out there? It also triggers the question, well, was this only found because they then filed their reports late, and there was something about the filing that triggered your realization that the tests hadn't been done, which goes to Commissioner Overturf's question, isn't there some way for the system to flag? Don't operators have to file reports when they spud the well, when they complete the well, when they frack the well, so that the system ought to flag when their reports on Bradenhead testing are due, or is that just not something we can track?
So to your first question, I think the reason why these 3 appear together is because I wanted them all to be in front of you at the same time. And like I said, this was the first wave. So we made every effort to make sure that all 3 of them were in front of you. Is there a way, backing up slightly, how did staff become aware of these first 3? I'm not 100% sure. It came to the engineering department, something in their review tipped them off. And then they made NOAV referrals. And then I guess can the system come up with a list of similarly situated operators? My gut is possibly, but it's something I'd have to check with the engineering department to see if they have the information necessary to audit, which is what it sounds like you're thinking would be appropriate.
No, actually, I'm looking for a way so we don't have to audit, so that the system automatically spits out the fact that there has been non-compliance. Because it seems to me that this did come up as a matter of audit, or as, I'm not entirely clear, but it ought to be an automatic system that's triggered because this test is so important.
So we do have, one of the joys of Colorado is the fact we have a breadth of data that we can query and get those answers. We can take a look at the date the well was spud, the date the well was completed, The fact that we have, so the various steps where we've asked it, we get data on that through our Form 42 with notices, Form 5 and 5A with when the well's completed, get those various dates, and then we can compare through the system with a query that we have, and we can see if we have our Form 17 that is the Bradenhead test that makes that. So we have queries. We have a variety of Bradenhead queries that the engineering staff review, and it's somewhat auto-generated. We use the term audit in that sense. So when Jeremy is saying audit, an automatic computer, it's not an individual grinding through hard copy files stuck in a corner anymore. We're a data-driven organization, but that's how it's done. Always in that perspective.
Great, that's very helpful. So the other question I had, Mr. Chair, on this was, why was extraction fined separately for each of several wells where this was a problem, whereas the other operators were allowed to consolidate a number of wells where they said, yeah, we had additional wells where we found to review that there was this problem, but they didn't get separately fined for those. Why? I didn't understand the distinction.
So the clearest answer is extraction simply had more wells than it did perform the necessary tests on. So we tried to come up with the best metric that we could to be fair to all operators. Extraction had the most. So what we did, you see in paragraph 8, is that we consolidated the penalties for subject well for the longest duration. So extraction, yeah, simply had wells than the other two operators did.
You're saying there was a consolidation for extraction, that just, even though there were these, maybe that went past me, but there were a number of violations that were separately identified, unlike with the others.
Yes.
It's the consolidation is that you were, for well A, you were supposed to test on this date, and you were supposed to test on this date, and you're counting that as a single violation. That's the consolidation, right? Is that per well, you're counting it as one violation from the date of the first missed test?
Well, it's per location. And by NOAB. So extraction, as you see, had more NOABs than Crestone and Cub Creek. Crestone had one NOAB, Cub Creek had 2, and then extraction had roughly 7. So it was consolidated by location, and then we chose the well at the location that was the longest out of compliance. That's what we penalized on.
Okay, so you didn't, and for each well on a location, you consolidated as to that location. But we still had several different locations laid out for extraction and not for the others.
Because they have more locations that were out of compliance.
Okay, so it's prosecutorial discretion, basically.
Yes, but we did try to treat each operator the same. Because extraction had more locations by a wide margin than the other two operators. So that's why they have the larger penalty, and that's why they have more NOABs. That's the purpose of how we came to the penalty.
Okay.
And just one point of clarification is that there's, you see the breakdown, the violations and the subject well, there is a 1 single day violation, which is 5,000, and then there's the other longer duration. So it is on each location, there's 2 separate penalty amounts. There's one, every penalty determination, there was a one day violation, and then the duration was the second component. So that varied by location and by operator.
Okay. The other comment I guess I would just offer on these is you allowed a significant part of the fine for extraction to be put toward plugging and abandoning orphan wells, which I actually thought was a great idea. And I'm wondering if we can use that more often. Seems to me a fairly elegant approach.
I think that's up to the operator to propose that public project. We usually don't push operators in terms of how they want to, if they want to perform a public project or not, or what type of public project. Obviously has to meet our rule criteria, regulatory criteria, but this was an idea by abstraction. And they did work diligently on this public project and what the details involved as well.
Probably a great thing to share at the next operators meeting.
Yes. I think that's the third time there's been a public project for plugging orphan wells. We like it, but Mr. Schultz is correct. We can't obligate somebody to do it, but if anyone's listening, please suggest that as an offset to your penalty.
Otherwise, what happens to the funds? They just go into the general fund?
They go into one of our funds. That's about as far as I know.
Okay.
Any other comments? Very well, we prepared to vote on these three as a group. Assuming hearing nothing, then that's what we will do. The docket numbers are 19010087, 19010088, and 19010024. All matters with respect to Bradenhead tasting. There is a motion to approve the enforcement orders for those docket numbers as written.
So moved.
Motion made by Commissioner Boygan, seconded by
Second.
Commissioner Overture. Just came in under the wire there. All approved, please, all in favor, please signify by saying aye. Aye. Opposed, same sign. Motion carries. Thank you all very much. Thank you. I guess, Mr. Ellsworth, you're not going to get any rest here.
And Chair Benton, as Mr. Ellsworth is beginning to set up his presentation, I can make just a brief introductory comment if you want.
Absolutely.
Mr. Ellsworth, and he's joined by Mark Schlagenhoff, who's also with the engineering unit division. He'll be providing you the results of a very extensive work group process that looked at the specific question that the commission directed this work group to look at, which was the use of instrument monitoring for flow lines. And after Mr. Ellsworth is through with his presentation, you have the opportunity to ask questions of him and Mr. Schlagenhoff. We would ask that the commission provide direction to staff as to what the next step should be. And Mr. Ellsworth will provide you the work group's recommendation, and if you're so inclined, you may provide direction to staff to undertake that recommendation.
Thank you. Mr. Ellsworth, are you ready?
Yes, thank you. What I want to give is a brief summary. I know there's a few new commissioners. Some of you were participants in our rulemaking a year ago, where you adopted 5 different sections about flow lines registration. 1102 is really deals with the construction of flow lines. 1103, placement of where valves are to isolate so you can do your various tests. 1104 is integrity management, and then abandonment is 1105. What this report is really trying to focus on is more of that integrity portion and the use of instruments. And that really came in the 1104 series. There are 11 different parts, but really this report is dialing in on an element in the ABO portion, audio, visual, and olfactory, or the fact, you are physically walking on site and looking for leaks. And in 11042J, it's the use of instruments. In other words, this was somewhat of a carryover from the CDPHE Reg 7 and the use of instruments. We've got a couple examples here, the FLIR camera, which CDPHE recognizes. It's an optical imaging camera. And then, of course, there's the influence monitors that are more personal monitors that I have here on the yellow. That's where a personal person would wear it. The cost range between these items, this is about a $500 item. The FLIR camera is a $100,000 item. And we have about 4 or 5 of those. But the point is as you're doing your walk around, you can utilize these various technologies. And so how can we incorporate those into the inspection of locations, inspection of flow lines? And so you asked us, well, when we were doing the rulemaking, there's a little bit of a disconnect in a way on how we could use these technologies. And so you asked us to panel a work group of industry, local governments, NGOs, and staff to evaluate the technologies, to evaluate if there was, how would evaluate risk and location, and then report back to you in a year and provide you some updates as we progress. On our website, under special projects, library special project, we've posted our progress as far as some of the meetings we've had, the presentations we've had. CDPHE came by and gave a presentation on their program. We did solicit 2 studies as far as from CSU. They've got a location called a MedTech site where they test a lot of these different instruments. They've got some facilities, some tanks, some separators. They actually do have a buried pipe that they can test these various pieces of equipment. So they have a large background on these various instruments. We asked them to do a literature review, to compile information on these various pieces of equipment. And their report has 19 different types of equipment that are utilized from influme, which is a sensitive gauge that you could walk around and if there's gas around, it'll sound off, to a optical imaging camera. That's an infrared camera. It really monitors, in a lot of ways, it's really not, one of the elements is the thermal, it's an IR camera, so it measures the thermal differences. And that's pretty good when you have the production, this warm production coming up, you can get a real thermal signature. It does have an ability for the infrared signal difference of particular VOCs, those items in the natural gas that you can smell. And so it does have that capability. It also has the capability to record. You look at this, you almost see it as an old VCR camera. So it has that technology that's pretty good. That is recognized by CDPHE. And then there's a lot of other technologies that they put in the report. Colorado School of Mines, we engaged with them to see if there were any upstream or flow line risk models that we could incorporate. We met 5 times, starting in November. The reason for a little bit of that delay was getting these reports to provide the background information for the work group so that they could review that and help with this process of writing this report. And then, of course, we're here today to give you this report. And you should all have copies of that, and these reports, or the literature reviews we got, we placed in the appendix section, and so those are available for your review. The CSU had kind of 3 key points that we thought were valuable. There's a lot of technology, like I say, 19 different types that they presented. Some of that technology is instruments, these remote instruments that you can walk around. Some of them were more technical, like cables. When you do construction, there's cables you can place in that construction that are product sensitive, that react when they get a hydrocarbon or water. They give a response back. Some of the technology was internal to the pipe. When you're monitoring the pressure or the various fluids by volume, flow rate, you can do them where you calculate if there's losses during that. One of the other internal methods is pigging, an expression where you put a tool in, you can measure the integrity loss or corrosion loss in the pipe. That's mostly for steel pipe though. But some of these tools, they really, particularly these remote tools, are really focused on gas and gas emissions, which may have a higher risk scenario, but they don't deal with the crude oil or the produced water. So that's part of the disconnect we had when we tried to create a rule that says you can use an instrument. Well, it's hard to create a rule when it only focuses on just one of the fluids that we deal with. So one of the key points that really came out of the CSU report is integrity management is a process, it's a procedure, it's a set of tools. It's not just one magic instrument that's going to give you that aha. It's a set, it's a procedure. That's what's important. And there's an API standard, API RP for recommended practice 1175. It's quite useful in defining that you need to have a process or a procedure, an operator manual that everybody buys in to this process. That isn't more of a what we call downstream, more of a gathering or the large pipelines, interstate lines, but it has a lot of key elements that could relate to these flow lines. So we also did an industry survey through the two industry organizations of CPC and COGCC. We created a survey, surveyed the industry to see what their what some of their processes were. Again, that's placed in the back of this report in the appendix. But there's two walkaways that came out. The two main instruments that industry used is this optical imaging camera, that is an IR camera. And CDPHE incorporates that and approves that. But one of the key things to keep in mind about the CDPHE program is that that is based on emissions from instruments. It's not based on pipelines or most particularly buried facilities. If you take a look at the CSU report, Dr. Schmitz, who was at the Color School of Mines, is now at the University of Texas Arlington. She had has a very good pit, buried pipe in a bed, and I like to characterize what her study was, how small of a detection can you detect? So she took an emission size detection, ran it through a buried pipe, and the result was a distributed pattern. It did kind of elongate with the pipeline, but by the time it went through the ground filtered it a little bit, and it was very hard to detect. And there's a graph in the report that shows you that you pretty much have to have your sensor right on the ground. Then you put in weather conditions. A small emission size leak is going to be hard to find with these remote instruments. So that's another statement on why you need an integrity management program and not just relying on one instrument. But the other instrument is this tunable diode laser absorption spectrometry. Sorry, but it's a laser technology, and it's generally called an inline. So it's a laser that is tuned to the specific gas. It's very good for methane. It's used quite a bit in the coal bed methane and in the dry gas areas. It's very effective. Of course, one of the disconnects is it's currently not a CDPHE recognized tool. So this drives us towards the fact that we don't want to just directly utilize one agency. We want to allow operators to use the tools that's most appropriate for their gas, for their fluid, and for their system. And then the optical imaging cameras, the positives about that, it's considered relatively affordable, $100,000 for an intrinsically safe, meaning you can use it on an oil and gas site. The lower cost of that would mean that it's not intrinsically safe. You need to be off the well pad when you use it. It's portable, it's easy to use in an inspection. It does have a video camera for documentation. It does need to have it's an element that you need to turn it on and let it warm up so it can do the thermal imaging. Of course, it is susceptible to ambient conditions. If you have a windy day, you can't really use it. And it's specific to gas. In the risk model, risk review that we had CSU do, or excuse me, School of Mines do, there were no upstream models that we could directly apply. So you need to look towards other type models. PHMSA, the Federal Pipeline Safety Group, they have a model that pretty much focuses on population, proximity to water bodies and right-of-ways. It's a little constrained, but they look and grade their systems. It's a safety protocol from grade 1 to grade 4. We at COGCC, and I have to my right here, Mark Slugenhoff, who is the integrity supervisor. His group established a model that I'll show in a second, but it's a qualitative model. It uses a few parameters as far as we utilize from our GIS system. We can take a look at where the municipal boundaries are. We look at the water bodies, trying to get where environmental risks might be. We also, through our database, we can track on a particular location the number of spills from we focus on, when we created this, we focused on well locations. So we have the date of when that well was brought into service. We can also know the inspection history of that location and if there's corrective action. And what we've created is a weighted average that then establishes a priority that we can then say, hey, we want to audit your production, your records. We want to see, operator, your integrity management program, and marketing's group is doing those audits. One of the things to understand about risk models is what you're looking at is a matrix. The idea of a risk model, this is how one of the School of Mines suggestions is that we try to incorporate more quantitative. And so the idea is to create a matrix of how many times an event has happened, what are the consequences of that event. When you do a qualitative model, you say, yeah, there's more risk if I'm near population. But in a quantitative model, you want to put a number to that. You want to do a probability of that event happening. So you can combine consequence and frequency to then get a probability to establish a risk. And so that's the idea that one of the things for us to look towards. And of course, there's 3 different kinds of models. The one I just mentioned was a qualitative model that we have. Yeah, I think it would be more risky to be near population, near water bodies. Whereas quantitative, you're trying to look at some statistics. How many events have we had? What are those events? What's the material? What's the pipeline material of that event? And get some statistics and then try to get some probabilities to that. So that would be a move towards a quantitative model, or you could do a model that might be scenario-based, where I think this scenario is a higher risk. So those are the type of models that would be a little more sophisticated than a qualitative model. So in this process that we have, COGC has this data Mark and his group have been looking at, since the 2015, our spill report, our Form 17, Form 19, and trying to look at audit that data for what spills are related to flow lines. Those are liquids. In our new rule, we established the Form 44, and we'll get information on gas releases. So we'll be able to add that in. But we took a look at these 4 different things as far as what was the fluid that was spilled, how was the leak discovered, what was the material of the pipeline, and what was the root cause. So here's those trends. And the first thing I'd like to you see is most of the spills, of course, this is going to be liquid dominated, and are produced water. And you see that blue bar going up is quite a bit larger than the others. And then the other thing you can see, so there's your blue bars. You can see that's our highest volume. Of course, the second would be oil. And you see we're starting to get, as our new rule, and we're starting to get some recognition of gas. Of course, this is the Form 19, so it'll be a gas release with some associated liquids. So we're getting those reports. The biggest thing, not only the second comment, is since Mark established his group, we're seeing a downward trend of all of those. So I think that's a strong positive. And of course, like a reminder, this is spills related to pipelines. The next thing is how were these discovered? And 34% were discovered by that visual inspection, doing a review right on the well location and getting that reported back in the daily rounds. That's the green 34%. And then I lumped all of these together, the next grouping of 42%. Those are when a construction activity is occurring. You're replacing a line, replacing a tank, doing some construction or abandonment, they found some spills. So these are all activities in which there's some kind of excavation or construction occurring. And then third party, that's where the local landowner is kind of reported those. And then 7% are physical production testing. Next question is, what are the root cause? What's the cause of this integrity issue? And you can see 41% are corrosion. My next slide is going to show the material types, and you'll see that's all dominated by steel, corrosion in steel. Second point is incorrect operation. Most of those are somebody accidentally left a valve open. And then the next one is pipe weld and joint failure. Again, the next slide is going to show you that that's mostly in the synthetic piping, polyethylene or PVC. You fuse those pipes together, and those are broken, and the result of that is mostly from bad bedding. So if you don't put proper bedding all the way around that synthetic pipe and you stress it, that joint, that's where it's going to fail, is at that joint. And that's what you see here when you take a look at the material and failure. Green is metal, steel pipes, and then we just lumped all the synthetics and composites together. So you can see the corrosion of steel pipe dominates as the failure mode. And then with the synthetics, you can see that it's that weld, that fusion joint. And so now kind of getting into the real kind of meat. What were our concluding results? There were 5 different findings. First one I kind of mentioned that really flow line integrity needs to be a program, a process, a management. There's no magic tool out there. It's just one of many. And you can see from some of the data that actually physically walking that line and doing that visual inspection, doing your pressure monitoring are really the best ways to do that. But you can incorporate some of these instruments into your ABO. The next thing is to understand that in the buried pipeline, which most of our pipes are buried, there needs to be an understanding of the difference between a small emission size release as compared to an integrity release. It's going to be a larger rate. And that's where we utilized, when we made these rules, we utilized the American Gas Institute Association's grade of one through 3, and grade 1 is where it's a hazard to the public. That was really our focus, and we want to report into that. And then CDPHE has a program, and coupled with the MedTech and their pathway to equivalency, have instruments they've approved in their AIMM program, AIM program. But that's not all the instruments that we think are possible for the pipeline world. And so, though we recognize their program, we want to be a little bit more dynamic and allow operators to utilize equipment more specific to their product. Some of the future considerations, things that we would like to continue working on, is this report we had CSU do, looked at the various technologies, but what it didn't look at is the cost. The cost of acquisition of the equipment, the cost of actually operating the equipment, and the cost of maintaining it. That cost range that I presented here is $500 for, that's a more personal monitor. You wouldn't really use it for this scenario. To a FLIR camera of $100,000, so if you can do a truck-mounted vehicle that's going to have a gas chromatograph, you're looking in the $1 million range. So the range of equipment is quite dramatic. So it would be nice to understand that. Now, EDF for the state of California did do a study, so there's some equipment, but they only looked at equipment. They didn't look at the operational cost or maintenance cost on that. So I think that's one thing we could take a look at. The next point is to take a look at some of the data we're collecting and see how we could incorporate at least some of those elements and refine our existing model and get some more quantitative elements. And then the last thing we need to do is keep track of those various equipments through the CSU pathway to equivalency. When they say pathway to equivalency, what they mean is creating a test location so that equipment or instruments that could be used for partially the CDPHE program and partially for our uses, they can explain how these different and get that on an approved instrument list. There are several agencies that I've listed here that are all engaging in this, and Mark and his group have been monitoring all those different agencies. And then there's one recommendation that the group put forward, and that is to construct a guidance document for this Rule 1104J2 for how to be able to use these instruments for the concept of integrity management. And that we will do as a separate document. We've constructed a draft document, so we don't quite have that done. So we'd like to continue on with that work. So in essence, let's not forget to thank you. These are all the people that participated in this. Our School of Mines and Dan Zimmerl leads that MedTech site, and Dr. Catherine Smith helped on the very tight. And the Colorado School of Mines, Dr. Fleckenstein and Dr. Herman both helped on those two reports. Sean Hackett from CDPHE, and we both helped and presented to us on their program. And then the big list on the bottom is a list of all the work group individuals who were very helpful in constructing this document. So in essence, what we're asking you now at this point is to accept the report and the recommendation to move forward with constructing the guidance document. And Mark and I are here to answer questions.
All right, I have a couple that get to some other commissioners who like to go first. So Commissioner Hager.
Thanks, Stuart. So just from a high level perspective, I think I remember when we were rulemaking, there was a lot of public comment that AVOs weren't good enough because you can lose gas in the subsurface, and that's why we tried to incorporate instrument monitoring. But there was general consensus that there's not a magic magic piece of equipment that's gonna do this correctly. And that's still the conclusion, correct?
Correct.
Correct. And that's, the conclusion is that you have to implement a set of tools
Correct.
to have a decent integrity management plan. Are we comfortable that our rules require that? I know that the inspection rules we require you could choose 2 of the following. Is that correct? And one is an ADO, and then on top of the ADO, you have to do continuous monitoring, pressure monitoring, or instrument method monitoring, or something else.
You are correct that in the rulemaking process, we constructed a matrix that defined timing of various rules. So your characterization is correct.
Right. And then I guess my next question is for Mark. It sounds like you've already started some of the auditing of integrity management programs.
Yeah, we've done.
Based on your risk assessment model?
Yes, we've done some audits of operators. It's an ongoing program. We haven't done as much this year simply because of the many rules, the interpretation of the rules, getting the Form 44 working and processing those.
Can you give any kind of indication of whether your findings are good or bad? I don't need specifics, but as you go through and the few audits that you have done, are you finding that operators have a decent integrity management plan that incorporates, or a program that incorporates more than one method?
Yes, I think most operators do have a good program. Most of the operators we have audited. You do have issues where you have older facilities, of course, and I would say that would be one of the bigger factors. If you remember back to the slides, where we have erosion, and obviously that's an age, typically an age-dependent quality. So that would be, but I think most operators do have a program, and I think we've seen some improvements since we've been working with specific operators.
Right, and then do you have any idea of how many of these audits you expect to do maybe in a year, or what the plan is for that audit program?
I think generally we'll do 1 to 2 a month going forward. If the commissioners want us, it's really a question of allocation time, because in Form 44 is new. We spent a lot of time, both internally and with operators. So our focus this past year has been basically on building a database. Once we get the database built, then we have better information that we can use to audit. If you recall back on some of the slides, in the new Form 44, we're going to be getting additional information such as what is the material of the pipeline. And that would give us additional clues as to where we want to audit, what we want to audit for. So that's been the focus here this year, has been on basically building the database. By October, the operators are supposed to have all their data submitted by the end of October. So at that point, we have a fairly deep set of data for the Colorado line systems covered by the rulemaking last year.
Okay, and then just one last question. As far as that audit goes, do you make recommendations? It sounds like it's up to the operators to decide which of the requirements they want to use in their integrity management program. But Stuart, I hear you say that really they need to look at equipment or methods that are specific to the product or their location. And so do you guys make recommendations sometimes if you think a better method might be appropriate for a high-risk facility, or one where you do get emission, big gas, you can measure it with a clear camera, instead of seeing it with your eyes when you walk it.
I'd say at this time, we are still in the developing of our new rules. And I do know that when we did the audits previously, we did give a response back, a letter response, and we engaged in that process. As we become more knowledgeable on these various pieces of equipment, I think that we could have an engaging conversation. And hopefully one of the things of the outcome of this report and it being published is operators will have an ability to review the materials we have here and see if some of those tools or instruments are usable in their case.
Right. Okay, I see one more. 19 technologies identified, that's a lot, and there's not a perfect one yet, but I bet it comes up. And so how will we continue to make sure that we're understanding the technology as it develops and making sure that we can require operators to implement best management or best technology?
Well, that's where we need to participate in those different agencies to learn what these new evolving technologies are, because there are many that are evolving right now, and engaging with these different groups, I think, is how we would become aware of that. Colorado State is doing a lot of work in this area, and I think engaging with them would be, and keeping that relationship would be very good.
Okay, thanks. That's all I have.
Yes, Commissioner Davis. Thank you, Mr. Chair. On page 22, you have a pie chart that reflects flow line related spills, root causes. And I was surprised to see the yellow part where it's 22% is incorrect operation. Can you give me some examples of the incorrect operation and I guess in general?
Well, that's where I say that's a good point. Incorrect operations, for the most part, were somebody left a valve open. And why someone would do that, I can't answer that question. But spill is related. So if somebody's emptying a tank and they walk away, and I don't know if it's an accident that they hit the valve or they, so it does happen. And so that's where most of those are. At least that's from my memory.
Yeah, if you look at our Form 19, there's a box for human error that gets checked off. Another case would be not only leaving a valve open, but you could say close a valve that led to an overpressure. So there's other cases, but typically related to human error. Another one we've seen checked off as human error is related to freezing, where they don't, just like in your house, if you go on vacation and you don't take care of your pipes could freeze. So that's one. You might say, well, that's really natural force damage, it froze, but it's also related to human error because you properly winterize your cabin and Bradenhead.
I would like to say that Mark's group does this review also on like a quarterly basis, semi-annual basis, and then in our monthly operator meeting, they report back to operators, and they do point out that, hey, look, there are some human error, incorrect operation scenarios that you've left a valve open. And so we have tried, that's one of the key points, is to feed this information back to industry so they can be aware of some of these root causes. It's corrosion. Well, you need to put your some biocide or corrosion inhibitor in your produced water to reduce that from happening. We try to keep this back.
It just kind of reminds me, like in Summit County, we have a bus system called Summit Stage, and there was a study that reflected that many of the drivers were getting injured during the wintertime. And we did analysis, and well, why are people, getting injured? What's the cause of that? Well, we found that folks weren't wearing proper shoes. In the wintertime, folks were wearing, tennis shoes, and they're slipping, and then we made sure they got the proper shoes, and when those rates went way down, and it was just almost like best management practices of little things that you can do that can really turn things around. But if I have a follow-up question.
Absolutely.
Can you give me an idea of how many operators you think will use the IMM to detect the leaks from flow lines moving forward?
Well, I think the answer is anyone that has gas on their location is required by CEPHE to have their Rake 7 monitoring of their equipment. So I'm trying to remember, it's in the report. I want to say that it was like 15 of 17 reported. It was that kind of a high number, so use that as a characterization. 17 operators responded to our inventory, commented they do use some kind of instrument, at least on the location. I think it'll be a high percentage. The question becomes on the buried pipe or off location, the fact that somebody needs to physically block that. This is probably a good opportunity to say something I forgot to say, and that is that in rulemaking and next month, the environmental group is going to report to you an example of kind of what we mean by multiple tools. We did a driving survey around in the Wattenberg field. We did that in conjunction with EPA and drove with a gas monitor system, more the laser technology system, I believe it was. But they drove around looking for gas emissions, and then so they drove around, and once they found something that they thought was a gas emission, then you go to that location and you do a more specific using one of these type more mobile systems, and you detail that system out. So that's a use of dual instruments, one a driving survey, where you get a regional perspective, follow that up with a location. So BP, I know, does that in the San Juan Basin, and in our rulemaking, I think it was Red Willow, the tribe, they did a survey and presented that as an example. And next, it's on our website, again, in the same location. This report was in library, special projects, but next month, they'll present to you that.
So, another couple questions, that's okay. All right. So, and it sort of relates a bit to what Commissioner Hager brought up, and it's assuming as we sort of go forward to this guidance document, I noticed in your other pie chart, I think it's a couple pages back. There we go. You sort of look at this and the flow line related spill discovery. Noticeably, about 62% of that was through either visual excavation or maintenance, more or less, sort of discovered after the cow you got out of the barn because the barn door was open. When you think about that guidance document, is it going to be also look towards more predictive processes so that you have an opportunity to predict, and then you can find somewhat the off-location flow lines to predict the potential occurrence of those rather than waiting for them to happen, so that as operators have some insight into what we could use for predictive tools to manage that better than waiting until we see them when we dig them up.
That's a good question. Hadn't really dove into that perspective. That's a more computational type scenario. We'll have to look into that. That might have to be a second document. Because now you're looking at, particularly in the steel world, you're looking at material loss computations. And it's very possible there's already an API standard that we could use to reference something along those lines. So maybe in this guidance, we could look towards that. But to some degree, that's the perspective you're trying to add is where we kind of need to figure out on this guidance. The draft guidance we have now is more how to operate those two pieces of equipment that I referenced before.
Because I was left with some concerns again on, to look at the other end, we stressed a lot about, well, ADO is not enough. Stress pressure testing and continuous monitoring, you look at that, only 11% of that total is found by the Institute technologies.
Sure.
So some cause for concern about stressing more in the future about trying to come up with some better predictive methods.
I think that's a great idea. And I think this is where we need to dive into the different materials. Steel, I can start to think about corrosion. I can start to think about an internal instrument where I'm looking at, where you can compute material loss, that internal tool looking at magnetic flux and ultrasonic, where you can tools that you can put into a pipeline that run down and then calculate material loss. You've got those kinds of things. Hopefully with the Form 44, we get maybe a statistical answer by, tend to get failures at this amount of time. Maybe we can come back and then say, this is what appears like a failure rate. And so it's an interesting thing, but that's kind of a deep,
fairly complex.
Yeah, it's a deep dive.
Yeah.
But now the synthetic pipe, you tend not to have corrosion, but the failures tend to be, like I say, these fatigues on joint due to bedding. And that's why we put in our rules, our new rules, the idea of regulations related to making sure you get proper bedding. So you make good points. We haven't, that will have to be a future perspective.
And temperature is also an issue with some of those synthetic materials. Yeah. All right, Mr. Boyd.
Thank you, Mr. Chair. I just mentioned real briefly something that you and I have discussed in the past. I'm aware of technology that is intended to identify weaknesses in pipelines that could ultimately lead to leaks. But obviously is intended to prevent them by identifying weaknesses beforehand with an algorithm-based system. And I just wondered, I didn't see any mention of that in any of the literature that was referenced or any of the surveys or studies that was done. It was all instrument-based. I'm wondering if that's been a part of the focus.
We did focus on instruments. That was the task that was put for us. But the CSU, Colorado State, did talk about computational type systems where you're looking at, this was more in the relationships of, you're looking at pressure, volume, rate, looking for where that's breaking down. Now that would still, the assumption is if I have a pressure breakdown, that I've got a hole in my pipe. A lot of these are, you're correct that the hole has already happened, and so therefore the leak has already occurred. But part of the idea is to find this early before you get to the total failure, is how I would like to try to present some of that. If I've got a crack in my pipe, I want to find that early before I have a catastrophic failure. So to some degree, that's a lot of it. What you guys are moving towards might be more where we start to do the probability answer. What's the probability rate of my corrosion? What's the probability of my failure? That you can do with a material loss scenario. But when you start to get towards some of these other scenarios, bedding failures, weld failures, it gets a little more different. So, but you make a good point. Something that we could probably look more at what are the computational type analysis.
That's the information I'm going to pass on to you.
Okay, very good, thank you.
Certainly, Commissioner Overture.
So first of all, I appreciate the amount of work and collaboration that went into the preparation of this report. It was really interesting reading to see all the different gadgets that are available and the different things that they can do. And so I thought it was good reading, strangely enough. So I guess I had a question about the recommendation that you put forward, and specifically creating a guidance document around 1104J. And I think what you're saying is that where an operator comes to you with a request to use IMM, that this guidance document would kind of lay out, these are the appropriate ones that you should or should not be using in a certain set of circumstances. Am I understanding that right?
I think that is where we want to get to this document.
Okay, and so I think that's a great thing to do, and that guidance is appropriate, and so I'm for the recommendation that you brought forward. I guess I wonder, kind of flipping back through rules and trying to remember when we went through this rulemaking process of adopting them, that my recollection is that, similar to what Commissioner Aber said, that for the various types of flow lines and the various types of things that are in those flow lines, there are different options that are available to operators, some of which are eligible for the use of IMM and some of which are not. I wonder, as you've gone through this process and you have come to this conclusion that this is really, you need to have a plan, you need to have a comprehensive look that has duplication in it, so that you're looking at different types of materials, different types of stuff in the pipelines, and the best way to address leaks for each of those specific circumstances at a particular site. I wonder if you feel like eventually it would be valuable to go back and revisit the rules that establish the standards about how the monitoring occurs, in order to require essentially the development of a site-specific plan for each facility that allows you an opportunity to look at all those different variables and say, yeah, this is a plan that works, that's more comprehensive. It's not just thou shalt do A, B, or C, but instead saying, operators, you need to come forward to us with a plan about how you're going to manage your pipeline integrity across the various pipelines you have and the various types of materials that you're piping, and we're going to evaluate whether that plan is sufficient.
I think where you're going is a good idea. I think that as a regulatory agency, it can be problematic for us to get into a plan approval process of integrity management, because I think that plans need to change and be dynamic. So the way we are approaching Mark's group's audit process is we want to see that you have a plan and that you're implementing that plan. That's where we've tried to focus our efforts at this point in time. But currently, I don't think the rules specifically state you have to have a plan. So that piece I'm okay with. If you were to revisit this, to say something along the lines of you need to have a plan and it needs to be site specific, but I'm cautious in saying I think we just need to have a plan. And the plan needs to be dynamic enough to be changeable in case, well, we convert all our pipes from steel to synthetic or something.
Yeah, and I think this is an interesting thing for us to continue to think about, in addition to trying to evaluate tools or methods that we may have to be more predictive rather than responsive to leaks. I'm very interested in those comments by Commissioners Benton and Boygan. But I also wonder if we want to take a look at recognizing that this isn't the way the rules work today. But as we progress, if it doesn't make sense to try to come up with site-specific plans and provide guidance for what those site-specific plans should include, at a minimum, recognizing that those are, of course, going to be dynamic and subject to change depending on circumstances on the ground. That's all.
Mr. Jolly. Are you seeing any companies come forward that are specializing in this as contractors that can be cutting edge, or do a little contract for the operators?
Yes. Many companies have reached out to us saying they've got the greatest tool and process, and new technologies. A great example of that is a ball that from a simple idea of locating these lines, some of these lines, some of these historic lines that have been out there. They've got those already existing in pipes that are 8 inches and larger. They're getting to smaller lines. Most of these flow lines are in the kind of 3-inch. They get a more tennis ball size, or excuse me, golf ball size ball that what it appears like you could do is you could have it's got a little bit of a gyro in it. You do a GPS location of where your riser is, and your start point. You put this ball in, it goes down the pipeline. It gets pumped through the line. It documents how it traveled in kind of an XYZ pattern, and then it comes out at the other end, and now you have the ability to map it. So they're with the micro technology and the fact that the use is being asked for, creative ideas are coming forward. That's one example. This quote, pigs, these internal tools are again getting smaller. They have those down to 6 inches. I think somebody was speaking to Mark about 4-inch size. It has pretty limited technology, but that gets more at steel pipe and this metal loss question and the predictability. I should comment that particularly in larger pipes, that one of the common ways to predict material loss or pipe thickness loss is what's called a coupon. It's a little piece of that same metal you stick into fluid and let the fluids pass through it, and you can periodically, say on an annual basis, pull that coupon out, and then you could then measure that fluid loss. So there's one tool that we can start using on some of these smaller size pipe. You can't get an internal tool to travel the whole length, but you can use a coupon method to computationally say, okay, here it is, and I've got this kind of metal loss. And you can also change your corrosion fluids percent. So if I have a coupon at one end and I have a coupon at the other end, this one where I'm injecting near to is fine, but this one at the far end, not, I'm getting metal loss there, that tells you need more of your corrosion protection. So there are some ways to do protection.
Interesting. Also, on the Form 44 compliance, are we seeing a lot of them come in? There's just going to be a flood of them in October.
Yes,
Wondering
today
how that is.
we've processed over 2,000 Form 44s. So we have maybe several hundred or more that we haven't processed yet. So it seems to be going along steady. There's probably some of the smaller operators maybe will have to do a little more hand-holding with than others. So we have had the operators meetings, we've had additional guidance and questions getting out. We've also added the possibility of more direct electronic data transfer from the operators to us on a field-wide basis, which should allow the operators who do have existing large databases to transfer their data over to us more efficiently.
Other commissioners? So, yeah, I think the direction they're headed, I think, is good. I'm always concerned a bit also about site-specific plans. So I think there should be some basic guidance in there that sort of encouraging companies to be proactive as opposed to prescriptive. Always a better place to be. So with that, are you looking for, maybe I should ask, Mr. Davenport or Ms. Larson, for you to
create this guidance document from us as a commission, and should that be in the form of a motion? With this general consensus amongst the commissioners to proceed as per your recommendation.
I think general direction from the commissioners to proceed further direction. So, no motions required. However, in terms of exactly what staff is looking for from the commission, I think Mr. Ellsworth or Ms. Larson would probably be better to that.
Well, you gave us a directive during the rulemaking, and this is our report, and this is our findings and our recommendations. And so I guess what I would be asking, have we met your ask? We're asking that we go forward with the guidance. Though I have heard you suggest that we need to maybe include some perspectives on predictive methods. I've heard you also say that we need to include maybe a guidance on how to create an integrity plan. So those may be separate documents. I think it'd be best, because otherwise this guidance I'm asking for right now would get out of hand. It might get large, and I don't want to get guidances that are, it's problematic when you get guidances more than 10 pages. So
I think you've characterized that pretty well. There's sort of three different things. What are the application instrument monitoring, and sort of what's appropriate given the conditions that you have? How to prepare an integrity management plan, which I think should be a pretty high priority, particularly for smaller operators that may not have put something in place. In reference back to sort of what we saw earlier today with Bradenhead testing, and the three companies that were in there, they all had to come up with a plan to do a better job at that. How do we get ahead of this for integrity management? And then lastly, the predictive one, which I think that's a lengthy process to actually come up with something. Commissioner Boygan has some ideas. I have some things to share with you.
Okay.
As well. So, Ms. Larson, how does that fit with your interpretation?
I think that's acceptable, certainly. And as you've provided more clarity or the more direction you provide us now, the better work product we'll be able to provide. So.
Commissioners, anything else you'd like to add to that guidance?
I would just,
Boygan.
Thank you, Mr. Chair. I would just add on this issue of preparation of integrity management plans and working with smaller operators, are there some ways, maybe there are contractors that specialize in that or who can be enlisted to create a regimen, a plan, or some kind of a methodology, or work with smaller operators. I guess we don't necessarily recommend specific companies, service providers, but I think we have to recognize that smaller operators don't necessarily have the resources to do what we're talking about doing.
Well, in part, I hope that one perspective to keep in mind with the smaller operators, their systems are smaller. And so they may not need as an elaborate plan as the larger, the horizontal drill operators that have an integrated system going from a multi-well pad all the way through a centralized facility. They're going to have a much more complicated scenario than an individual operator that's a single well, single tank scenario. So there is perspective in that range.
But they're also going to have older systems.
Well, true.
As Stuart knows, we have over 1,000 miles of older systems, so an IM plan for us has been a very high priority as an operator, getting one put into place.
Well, I can say that operators have come forward with more sophisticated plans. They're doing some of the predictive stuff. They're pigging their lines. They are replacing lines that might be in those sensitive areas, under pipelines, under water bodies. And so I think since 2015, the conversation has grown, and the perspective has grown, and the fact that people need to be monitoring these systems, people are more aware.
I'd like to mention too, we do have on the 2A on certain locations, there's a requirement to include an instrument monitoring plan. So it has been, I think it's only in the urban locations, but there are some plans available on our website already, so.
Okay. I think you have our commissioners, I believe you have consensus amongst us to continue to proceed with the application of instrument monitoring. Certainly would like to investigate finding some additional guidance about how to prepare an integrity management plan, whether that comes from other operators, from outside contractors, what you have in place, something along that line. And then thirdly, for the sort of the long haul, is that how do we continue to improve our ability to predict those potential failures, which I think is just going to be more collecting that data and how that's going to be analyzed.
Very good.
All right.
Well, thank you.
Thank you very much. It's great work. All right. I think next on the list is a motion to go into executive session, but I think Mr. Davenport needs to read something first.
Mr. Chair, thank you. This is Assistant Attorney General Kyle Davenport. Pursuant to open meetings law, the commission is entitled to enter into an executive session at this regular meeting for the purpose of discussing pending or imminent court action with the commission counsel and to receive legal advice pursuant to Colorado Revised Statute Section 24-6-402 3A Roman 2. The topics of the executive session were identified on the agenda for this meeting. They are, I will briefly summarize them. In the matter of litigation of Wildgrass Oil and Gas Committee v. State of Colorado et al., U.S. District Court for the District of Colorado to receive legal advice and analysis on the claims and defenses in that lawsuit, as well as the legal issues raised by the February 12th order from the court. In docket number 1810-00799 to receive legal advice and analysis concerning the legal issues raised by Wildgrass and affected Coloradans Together's protest of extractions pooling application. In docket number 1903-00337 to receive legal advice and analysis concerning the legal issues raised by the potentially commission's consideration of the issue of whether or not the Form 2 and 2A filed by Extraction for Development and Lands covered by orders numbered 407-2256 and 407-2274 comport with the October 24, 2017 amended and restated oil and gas operator agreement. In the matter of Wildgrass Oil and Gas Committee v. COGCC and Extraction, Denver District Court to receive legal advice and analysis on the claims and defenses in this judicial appeal, as well as the legal issues raised by this pending court action in the matters that the commission will hear tomorrow, which I previously named. In the matter of Battlement Concerned Citizens v. Grand Valley Citizens Alliance v. COGCC, Denver District Court to receive legal advice and analysis as authorized on the claims and defenses in the judicial appeal in the matter of Larson Front Range Farms et al. V. COGCC and Extraction, Denver District Court to receive legal advice and analysis on the claims and defenses in the judicial appeal, as well as the court's recent grant of motion to dismiss. And finally, in Weld Air and Water et al. V. COGCC and Extraction in the Colorado Court of Appeals to receive legal advice and analysis on the claims and defenses in judicial appeal, as well as in the potential upcoming oral argument in that matter. Mr. Chairman, I invite you to encourage a motion to enter into executive session for the matters and purposes I just named.
I will encourage that motion.
So moved.
Motion made by Commissioner Boygan, and someone like to second that. Seconded by Commissioner Gibbs. I saw your head go up and down, so I'll presume that'll be okay. All in favor, please say aye.
Aye.
Aye. We are in executive session. I think given that length, we have an hour and a half, I believe. Is that what you want? It is actually 12:30.
Right.
Yes, Ms.
Yes,
Larson.
Mr. Chair, so we had scheduled originally to break at noon and to come back at 1:30, but I do agree an hour and a half would be more likely beneficial to you all for that. So I can let the parties know who are scheduled to be here at 1:30 if they could please be here at 2.
Let's do that, please. Thank you very much.
And just one last item, we will be in a conference room on the second floor where your lunches will be provided. So if you wish to grab a beverage to take with you upstairs, that would be good.
Thank you.